once, twice a year.
And what kind of law did you practice?
Really don't know.
You don't really talk about work?
No.
Despite having that relationship with her, will you be able to be fair and impartial?
Yeah.
You?
I'm frontline attorney. Top of court, so,
Okay, can you talk about his work?
not really.
And despite having that relationship, will you be able to be fair and impartial?
Yeah.
Other hand, number two?
Have the sons of two friends who are attorneys.
Do you know what kind of law they practice?
So one is Matt Lowell, I think it's personal injury, and the other one is Jeff Hakish, and I don't know what he practices.
You talk to them about work often,
Never.
and despite having that relationship, will you be able to be fair and impartial?
Yes.
Back row there, number 11?
Yeah. Brother-in-law, niece, both attorneys.
What kind of law?
Everybody gets.
Despite having that relationship, will you be able to be fair and impartial in the case? 16?
My brother's the corporate attorney.
Okay, do you ever talk to him about work?
No.
Right. Despite having that relationship, will you be able to be fair and impartial in this case?
Yes.
35?
I actually did law school.
Okay, did you talk to her about what she was learning?
I try not to talk to her at all.
Okay, all right, fair. When you were together, however, would you talk about,
No, not really.
all right, and despite having that relationship, are you able to be fair and impartial in this case?
Yeah.
Don't hold it against me, okay? All right. Anyone else? All right, as you already know, this is a possession of cocaine case. The actual drugs are gonna be in the courtroom. They're gonna be sealed in plastic a few times. I promise that they're safe. But knowing that the drugs are gonna be in the courtroom, does that make anyone uncomfortable? Recently, Ohio voted to legalize recreational marijuana. Who here supports that? A lot of hands, okay? What about medical marijuana? A lot of hands, okay. Does anyone here think that all drugs should be decriminalized? Right? It's your body, not my business what you put in it. Anyone feel that way?
Will you repeat the question, please?
Oh, yes. Does anyone here think that all drugs should be legalized or decriminalized? Your body, not my business what you put in it, do your thing. No? You're gonna hear from the crime lab analyst in this case. Who here knew that we had a Lake County crime lab? Has anyone taken a tour or visited? Yeah, 20?
I was in the grand jury.
Oh, okay. Wasn't that fun?
Oh, that was awesome.
Does anyone here know someone that, oh,
I think I may have in my class, and I don't remember.
oh, when you,
I
what's your number?
27.
27, thank you.
I think I vaguely remember.
Okay. Does anyone know any, oh, 4?
Yeah, my previous IT role here, I also supported the crime lab, so, and I'm terrible at names, but I do know it.
Okay, thank you. Yes, does anyone know anyone that works at the crime lab? Number 4, despite knowing the faces, will you be able to be fair and impartial and judge any testimony in a fair and impartial way?
Yes.
Okay. Does anyone here have training or experience in DNA or forensics? Okay. And you're gonna hear that the evidence in this case was not sent for DNA or fingerprint analysis. Does anyone here need to have DNA or fingerprints in order to find a guilty verdict? So we all have human emotion, whether it's sympathy, empathy, anger. We can't ask you to leave that at the door when you walk in here. However, it's improper for you to base your decision on those emotions. You can't base a decision because you feel bad for the defendant or because the state has done something to anger you. We all agree to base your decision on the evidence and the law and not emotion. And the judge did already touch on this. The burden in this case is beyond a reasonable doubt. And beyond a reasonable doubt does not mean beyond a shadow of a doubt, does not mean beyond all doubt. And the judge leave here, be ready to instruction, and you'll hear it again. Does everyone have a preconceived or does anyone have a preconceived notion of what beyond a shadow of doubt, or beyond reasonable doubt is? We all agree to follow the law when it comes to beyond reasonable doubt. And to not hold the state to a higher burden. All right, I think that's all from me. Thank you so much.
Ms. Carroll?
Thank you, Ron.
All right, good morning, everyone. Can everyone hear me? I have a tendency to talk quietly, so if for some reason you can't hear me at any point, just raise your hand and let me know. So I'm gonna echo the sentiments of the prosecutors. I wanna thank you for being here as well. I know it's probably not your first choice of a way to spend a Monday morning, but, we do appreciate it, and Mr. Fleet appreciates it. So the prosecutor and the judge have already touched on most of the topics. I'll just have a couple of follow-up questions. So with respect to the drugs, did state that this is a possession of cocaine. Does anyone have any personal experience with friends or family members having issues that would make that hard to hear today? Number two?
My nephew died of a drug overdose.
Okay. And how do you think that that'll affect you going forward today?
I can't really say, I don't know, I mean, I don't think it would, but it's in the back of my mind.
Okay. Do you think that would make you think of drugs in a more, in either one way or another towards whether you can possess them or didn't possess them, or do you think that that would just be in the back of your mind?
I think it would be in the back of my mind.
Okay.
I think everything, I haven't heard anything yet, so I
Okay.
don't know for sure.
But you don't think that that would influence you to
I wouldn't
sway one way or the
necessarily-
other?
I wouldn't necessarily from the start say.
Okay. Okay. Anybody else? Twenty-four?
My former brother-in-law, and then also just every day on the job,
Okay.
so many calls that we get for either ODs or just somebody out of their mind on narcotics.
Okay, and do you think that that would influence the way that you view the evidence in this case?
Again, it would have to be, the preponderance of the evidence to see how everything plays out. It's
Well,
not
and-
always clear cut.
Okay, and you're saying preponderance of the evidence. So as the judge and the prosecutor stated, the burden of proof in this case is beyond a reasonable doubt. And so preponderance of the evidence is a lower standard, so, what the standard here is beyond a reasonable doubt.
Here's where I'm at with all this. We're already here at common pleas. He's already been through a couple other sessions to get us up there.
Hold on a minute. Let's move on to another question, okay? Now, let me see counsel real quick.
Turn it down.
Go ahead, Ms. Carroll.
Thank you, Ron. And then Ms. Bell also talked about, if anyone is involved in an accident or witnessed an accident, had any interactions with a police officer and how they handled it. Has anyone had any other interactions with police officers that was a negative? Everyone's had positive experiences? Okay. And then because of those positive experiences, does anyone think that that would influence the way that they view testimony from, let's say there's the person from the lab coming here to testify, and then say there was an officer on the stand coming to testify? Would you view one of those testimonies as more truthful than the other, or would you base that on be the first, where you weigh one of those testimonies higher than the other. Everyone could make that determination based on the testimony, based on the person that's up there, what their body language is, what the video shows, what audio records, everything like that, and not just on the fact that it is a police officer or it is someone that works in a lab. Okay? And then, so in terms of Mr. Pate testifying, that is, there is a constitutional protection that protects Mr. Pate that says that he does not have to testify. Does anyone feel that they would require him to testify in order to find him not guilty? Does anyone think that that would make them think less of Mr. Pate, or think that he's more likely to be guilty if he's not testifying today? No? Okay. And with respect to the presumption of innocence, so Mr. Pate being here today, he is proven innocent. The fact that he has pled not guilty, the fact that we're here for a trial, that does mean that we are disputing the facts in the case. We are disputing the charges, and so as he sits here right now, Mr. Pate is innocent. He only would be found guilty if at the end of this trial, you were to find that the prosecutors have met every element of each of the offenses that he's charged with. Does anyone have a problem with viewing him here today, sitting right here as innocent? Nope. Okay. When anyone walked in this morning and saw Mr. Pate sitting here, did you think, I wonder what he did? Nobody? Okay. So part of the process that we're here for today with the questioning is to try to get everyone out of the mindset of your natural tendencies of, you're in a criminal trial, what did someone do? We're here to get the legal standard, listen to the evidence, and then make a decision based on the instructions you get from the judge. Does anyone think they'll have an issue with stepping out of the shoes of just an everyday citizen walking down the street, and a juror coming in here today and following that set of procedures? Okay. And Ms. Bell also started talking about the burden of proof, the beyond a reasonable doubt standard. Does anyone think it's unfair for the prosecutor to have to prove this? Does anyone think that Mr. Pate should have to prove his innocence? No further questions. Thank you, everyone.
All right, thank you. All right, at this point, ladies and gentlemen, I'm going to excuse you out into the hallway. And when you go out there, you can talk about anything you want to talk about, with the exception of one thing. That's everything we've talked about in here since 8:40. That's completely off limits. So feel free to talk to each other, but stay away from that subject. When you come back, I'll have met with counsel, and then we will identify the 13 individuals chosen to be the trial jurors in this case. the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has the Fifth Amendment right not to testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. During the course of this trial, a number of exhibits and testimony relating to these exhibits may be introduced as evidence. You will determine what weight, if any, the exhibit should receive in light of all the evidence. Jurors will be permitted to take notes during the trial. Jurors will not be permitted to ask questions from the witnesses. It is the responsibility of the lawyers to present all the evidence necessary for you to decide the issues in this case. You will not be permitted access to transcripts of witness testimony during your deliberations. Please be aware that once deliberations have begun, you may not have contact with anyone other than your fellow jurors and the bailiff. This means that once deliberations begin, you will not be able to make any phone calls. We will give you advance warning when we're getting close to the end of the case, so you can let the necessary people know that you will be out of contact once the deliberations begin. You can be reached for emergencies, but if you're called out of the jury room, you will not be permitted to return. It's important that you be fair and attentive throughout the trial. Do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. Wear your lanyard so that the attorneys, parties, and witnesses know that you are jurors and off limits for conversation and contact. It may be difficult for you to understand why you may not discuss this case among yourselves until it is finally submitted to you. You will receive the opening statements, the evidence, the instructions of law, and the arguments of counsel. It would be unfair to discuss the case among yourselves until you receive everything necessary to reach an informed decision. You should explain this rule prohibiting the discussion of this case to your family and friends. When the trial is over and your jury duty is complete, you will be released from that instruction. At that time, you may discuss the case and your experiences as a juror if you wish. I'm going to give you what's called the admonition. It's a standing court order that applies throughout the trial. If I forget to remind you of any portion of the admonition before a recess, it still applies. You have been selected as jurors in this case. We've taken the time to seat a neutral jury so the case can be decided based just what goes on in the courtroom and not on outside evidence. You are required to decide this case based solely on the evidence presented to you in the courtroom. It is my role as a judge to determine what evidence is admissible and what evidence is not admissible. It would be a violation of your duties and unfair to the parties if you should obtain other information about the case, which might be information that is not admissible as evidence. You must carefully listen to all the evidence and evaluate it. Do not reach any conclusions until you have heard all the evidence, my instructions of law, and the arguments of the attorneys. Otherwise, you will have an incomplete picture of this case. Do not discuss this case among yourselves or with anyone else. The reason is that you might be given information or an opinion that could alter the way in which you view the evidence or the instructions or even how this case should come out. Such an opinion or conclusion would be based on an incomplete or inaccurate view of the evidence and would therefore be clearly unfair. In addition, you must not try to get information from any other source. This ban on outside information also includes any personal investigation, including visiting the site, looking into news accounts, talking to possible witnesses, reenacting the allegations in the indictment, or any other act that would otherwise affect the fairness and impartiality that you must have as a juror. Finally, you must not have contact with anyone about this case other than me and the court employees. This includes viewing any social media sites of any kind regarding this case or any aspect of your jury service during the trial. If anyone tries to contact you about the case directly or indirectly, do not allow that person to have contact with you. If anyone persists in contacting you or speaking with you, that could be jury tampering, which is a very serious offense. If anyone contacts you in this manner, report this to me or the bailiff as quickly as possible. You should know that if this admonition is violated, there could be a mistrial. A mistrial means the case is stopped before it is finished and must be retried at a later date. This can lead to a great deal of expense for the parties and for the taxpayers. If a mistrial were to be declared based upon a violation of this admonition, the juror responsible could be required to pay the cost of the first trial and could also be punished with contempt of court. Counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, opening statements, Ms. Mulligan?
May it please the court, counsel, ladies and gentlemen. The purpose of the opening statement is to let you know what you're going to hear, what to expect to hear. And in this case, it is quite straightforward. That on September 28, 2023, at the apartment in the Fox Run area of Willoughby, the Fox Run apartment, Lake County, Ohio, a person by the name of Kevin Corkin called 911 to say a person had threatened to kill him. Response to that 911 call, officers were dispatched to Kevin Corkin's apartment. Now, the police serve everyone in the community. Not the people that they like. They serve everyone. It so happened that Detective Burrington and Detective Slay were at the office of the apartment complex investigating a reported theft at the time that this 911 call came through. The reported theft, the victim was Kevin Corkin. He said 2 days earlier that his money had been stolen. He reported that to the police and named DeMarcus Pate as a possible suspect because DeMarcus Pate was staying in an apartment in the next building over his apartment complex. The threat. Because DeMarcus Pate understood that the police had been called. And he went over to Kevin Corkin and said, "I'm going to kill you." He said it in a number of ways. He balled up his fist, almost hit him, pulled back, and then said, "People get killed for this sort of thing." Kevin Corkin, not knowing exactly what he was hearing, saying, "Are you saying you're going to kill me?" And the defendant, DeMarcus Pate, smiled and nodded his head and left. Kevin Corkin immediately called 911. You're going to hear that 911 call. You're going to hear that Kevin Corkin is a little different. And then you're going to see that Kevin Corkin is a little different, and you might even smell that Kevin Corkin is a little different. He is part of the community. And the police respond to that. Because the detectives are nearby, they go to Kevin Corkin's apartment, and there's also a uniformed response that comes to Kevin Corkin's apartment. The three officers talk with Corkin very quickly. They talk with one of the neighbors very quickly. They come to the conclusion that DeMarcus Pate should be arrested for an aggravated menacing, for causing Kevin Corkin to believe that he, DeMarcus Pate, was going to cause serious physical harm to Kevin Corkin. They decided that he should be arrested. They went to the apartment where they knew DeMarcus Pate to be staying. They knocked on the door. A woman answered. They said, "We need to talk talk to DeMarcus Pate. DeMarcus Pate came to the door, and they arrested him. They arrested him for the aggravated menacing. And during the course of the arrest, as any prudent police officer will do, they patted him down to make sure he didn't have any weapons, to make sure that they're safe. And what do they find in his front pants pocket? They find a baggie full of powder. And what does DeMarcus say? He says, "That's powdered sugar." Well, let's see if it's powdered sugar. They took it to the crime lab. You'll hear from the analyst, and you'll hear that during the course of a lawful arrest for an aggravated menacing, DeMarcus Pate had in his possession 26.51 grams of cocaine, a Schedule II substance. You'll hear from the dispatcher, you'll hear from Kevin Corcoran. You'll hear from Detective Gabriel Slay, who's part of the response team, along with Detective Burrington and an officer in uniform, Officer Blackstone. The three officers were all there together at the same time. We're just gonna bring one. You don't need to hear everybody. But you're gonna hear a little bit because the Willoughby Police Department don't have body cameras. They have cameras in their cruiser. And because that uniformed police officer, Officer Blackstone, had a microphone that relayed to his cruiser, you're gonna hear a little bit. You know, some of the mumbly stuff because you can't really hear inside a building from the relay. But once they come out of the building, you're gonna hear, "That's my powdered sugar." And you're gonna hear from the officer who came to the scene too, who packaged this up, put the case number, the police agency number on it, his initials on it, and booked it into the evidence locker at the police station. And then you're gonna hear from the laboratory analyst who's gonna say, "I got this, and it was in this condition, and it was sealed with the initials, and I opened it, and I performed tests on it. And I determined that it's a Schedule II substance. That Schedule II substance is cocaine, and it's 26.51 grams. That's what you're gonna hear. And at the conclusion of the evidence, the state is gonna stand before you and ask you to convict DeMarcus Pate of possession of cocaine and aggravated menacing. Thank you.
Thank you, Ms. Carroll.
Thank you, Your Honor.
Good morning again. On behalf of my client, DeMarcus Pate, I'd like to thank you again for your time and effort in this important civic duty today. Today is an important day in Mr. Pate's life, and we thank you in advance for giving this child your full attention. As he sits here today, right now, Mr. Pate is innocent. Just as I explained during jury selection, he remains innocent of each charge until the state of Ohio proves each and every element of each and every offense, and they must prove this to you beyond a reasonable doubt. This is the highest burden in our legal system. This is a more difficult standard than what has to be shown for a multi-million-dollar award in a civil trial or for someone to have their children taken away from them in a custody dispute. Throughout the course of this trial, we anticipate the state of Ohio will call to testify a few witnesses to present a story of what they alleged happened. There will be some facts throughout the trial that we do not dispute, but what will be important during this trial is noticing which testimony or evidence is not present. Either not present, or misconstrued, or doesn't make sense. So we ask you to notice those things today. We ask that you listen carefully to the facts, hold the state to their burden, and not make any decisions until you've heard all of the evidence.
Thank you. State's first witness.
The state calls Kim Cast.
You raise your right hand, please. You swear to testify you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
All right, have a seat right here. And do your best to stay close to that microphone, okay?
Yes.
All right, Ms. Mulligan?
Good morning.
Good morning.
Could you tell everyone your full name and please for us spell your last name, if you would?
My name is Kimberly Castee, last name K-A-S-T-E,
And Ms. Cassidy, where do you live?
in Lake County.
And what is your occupation?
I am a police, fire, and EMS dispatcher for the city of Willoughby.
How long have you been a dispatcher for the city of Willoughby?
A little over 2 years.
Did you receive any kind of training to qualify you for this position?
Yes.
Tell us about that.
I have public safety, telecommunications training, and then the maintain APCO international training.
And what do you do as a dispatcher for the city of Willoughby?
I answer emergency and non-emergency phone calls.
So when somebody calls 911, are you the person that answers?
Yes.
And going back to September 28th of 2023, were you working that day?
Yes, I was.
And did you have an occasion to take a 911 call, ultimately from a person you learned was Kevin Corkin?
Yes.
And do you recall roughly what time of day that would have been?
A little after afternoon, not exactly sure.
I have limited mobility. Okay. I am going to squeeze through and ask you, may I approach, Your Honor?
Yep.
Thank you. Show you what's been marked as State's Exhibit number 1.
Okay.
Do you recognize that?
Yes.
What is that?
It is a recording of a phone call from September 28th.
And how is it that you know it to be that?
I listened to it before coming in here, and then I initialed it.
Does it fairly and accurately
Yes.
reflect the conversation that you had on that day?
Yes, ma'am.
With the board's permission, I'd like to play.
All right, go ahead. Is there any objection to one?
No, Your Honor.
All right, go ahead and play it. I want to inform the jury that before you hear this recording, it was edited by agreement of parties and approval by me, because there's information taken out that is not pertinent to this case, and therefore you're to ignore the fact that there are edits and consider this exhibit only for what you hear.
Let me ask you a couple questions before we just do this, but
Okay.
when someone calls 911, do they always sound the same when they're on the phone with them?
No.
What are the differences, if you can?
Some people are excited, some people scream, some people, different choice of language, whether they're swearing. Some people are calm. There's not a standard for callers.
Do you infer the need for urgency based upon the sound of the voice of the individual that's calling?
Not particularly, because there is no standard.
All right, let's play.
Where is your emergency?
It's, 13443 Fox Run Drive.
Is there an apartment number?
Yeah, 207.
207?
Yes.
Okay. 1344 Foxconn apartment 207, what's going on?
My neighbor across the building across from me threatened to kill me twice and to hurt me. So,
What's your, are you inside your apartment, and are they inside of your apartment?
they were banging at the door about 2 o'clock, and he threatened to kill me outside my door.
Okay, is the door locked?
Yeah, it's not gonna matter.
Okay, what is your first name?
Oh, what am I gonna do? Kevin.
What is your first name?
Kevin.
Okay, what's your phone number, Kevin?
440-231-2287. 2058.
Okay. What is, do you know his name?
Yeah, his name's D. He,
Okay. Did you,
and pretty much all the neighbors, so, I've been seeing him.
do you know if he has any weapons, or were you unable to see him? Okay, but again, just making sure your door is locked, correct?
Yeah, guns out there.
I understand that, but I need to make sure that there's some, some type of separation. I do already have officers around, my partner already dispatched them, so we're already on our way up there, okay?
Hey, how do you handle this sort of thing, should I
Wait in your apartment until the officers get there. Do not open the door until the officers come. I will let you know when my officers are there, okay?
Yeah, I guess that is that part.
Well, then, I mean, you can use the officers afterwards, but like I said, I'll let you know when my officers get there. Wait for me.
Okay.
Do you know if he's still outside of the apartment, or you don't know?
I know it's raining, not gonna be a good day.
Do you know if he's still outside the
I
apartment?
heard you, all right? Right.
Well, can you
I don't know.
Okay, that's what I need to know. I need to know if he's left or not. Are you able to see, or you don't have a window that goes in your direction?
I'm looking. You know, I just didn't go back there, he's not outside of my apartment either.
And you're in apartment 207?
Yep.
Okay. He's not knocking on the door anymore, though.
Do you try to stay on the phone with the caller?
Typically, yes, depending on the situation.
The officer is at the apartment complex, he's just coming back toward your building, okay?
Okay.
So like I said, until you know it's my officer, don't open the door. We also have more officers coming up. Right?
Okay.
All right. I'll stop you up there, so just make sure you have before you open the door. Thank you.
Thank you, I have no more questions.
Cross-examination?
Thank you, Ron. Head over to the podium. All right, so Ms. Morgan kind of brought up in the beginning that different people handle different situations differently, but in this situation, Mr. Corkin on the phone seemed to be very calm, right?
He appeared so.
Okay, and, if anything, maybe a little, I don't want to say hostile, but at some point he was kind of frustrated with the conversation. He said, "I heard you, Jesus."
He did say that.
And then another point, he seemed distracted, where he said that it was raining, it's not gonna be a good day, when you're trying to get further information about the alleged threat.
He did.
Okay, and then when he was on that call, he only referred to the individual that he said threatened him as D.
Correct.
Okay, and then he also stated that all of the neighbors heard it.
He did make a comment, the neighbors heard it.
Okay.
I have no further questions, thank you.
All right, any, redirect?
Would it be accurate to say he sounded agitated?
Correct.
No more questions.
Anything based on that?
No, Your Honor, thank you.
All right, you may be excused, thank you.
Thank you.
All right, next witness.
State calls Kevin Corkin.
I know. Will you raise your right hand, please? You swear the testimony about gives the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, have a seat right here, right around here. Stay toward the front so that microphone can pick up your voice, okay? Ms. Mulligan?
Good morning, sir, if you would. Would you tell everyone your full name, please?
Kevin J. Corkin,
And spell your last name for the record.
Corkan,
Where do you live, Mr. Corkin?
at 1343 Fox Run, at apartment 207.
How long have you lived there?
8 months?
Going back to September 28th of 2003, were you living in that apartment at that time?
Yeah.
And that apartment is in Lake County, Ohio, correct?
Correct.
Now, going to September 28th, 2023, did you call 911 that day?
Yeah, I think so.
Okay. Why did you call 911?
My money had gotten stolen, and they were investigating DeMarcus, and he came by and threatened me.
You said that your money had been stolen. Did you report that to the police?
Yep.
Did you report that before the threat was made?
Yeah, I think like 3 or 4 days before.
And you said your money was stolen. Did you name DeMarcus Pate as a suspect?
Mm-hmm.
How do you know DeMarcus Pate?
He lived in the building across from our rental building, like across from 1343. And we like smoked outside one time and met just one day.
And you had reason to suspect him in a theft that you reported, correct?
Yep.
Did you tell him about the theft? Did you tell DeMarcus Pate about the theft?
That I'd reported him?
Yeah.
No, I didn't tell him.
Was there a time that you became aware that he probably suspected that?
When he came over and threatened me, yeah.
Okay.
That was,
Tell us about that, when he came over and threatened you.
I think it was like 9:30 in the morning. I was like in a blanket when I answered the door. He was like pounding on the door, and he basically told me, "Hey, I found out the police are investigating me. I want you to get them to stop." And I was like, "No, I'm not going to. Let me go back inside and get dressed." He didn't want to do that. He dragged my neighbor out and got her involved in an argument. And yeah, you want me to give the full everything
Well,
that
yeah,
happened?
your apartment is, your door to get out of the apartment faces into a hallway?
Mhm.
Is that right? It's not out into the open to outside?
Yeah, you enter the building, go up the stairs, and to the right is my apartment. So he was upstairs in front of my door.
Okay. And you said this confrontation happened inside the hallway there?
Yeah.
By your doorway?
I came out of my room and it happened in the hall, yeah.
And did somebody else come out of their room?
Valencia, my neighbor, Dee knocked on his door and kind of like brought her out for some reason.
Okay. And what happened there? What did the DeMarcus Pate say out in the hall there?
He tried to get Valencia to side with him, and she wouldn't take a side, and I basically refused to get the police to stop investigating, because I knew 100% it was him, because the only other thing missing was a vaporizer pen that he liked. And that was the only other thing missing, so to me, it was kind of obvious it was him. And, yeah, I wasn't getting, like, drawn into it, and he kind of made a move to, like, come at me and punch me, but pulled himself back.
You say made a move, what did he do with his hands?
He kind of, like, he took a step forward and was doing, like, the fist, that, you know, when someone moves to punch you, but he stopped himself.
Okay. Did he say anything when he did that?
No, he just made a face and went to do that.
Did he say anything to you?
Yeah, after that, when he was moving to go down the stairs, he said, you know, I used to be in a gang, and we used to kill people for stuff like this. And I asked him, does that mean you're gonna try to kill me over this? And he shrugged at me and nodded yes. So I called the police right after that.
What did you think when he said, yes, this means I'm gonna kill you?
I wasn't sure if he meant it or not, but I wasn't gonna risk that, so I just called the police immediately. I don't know.
Did you believe he was gonna cause you serious physical harm?
He said yes. So,
And did you call 911 right away?
yeah, basically.
And after you called 911, what happened?
Apparently the police were already in the neighborhood about something else. So within like 2 minutes, they were in his building, and they arrested him, and they found like cocaine or something too.
Did they come talk to you first?
No.
You know? Did you talk to police officers in your hallway?
Yeah. After they. Did they talk to me?
You said that they came within 2 minutes or so? Was
It
that?
was very quick. Yeah, it was within 5 minutes.
The whole thing, about how long did it take?
About a couple minutes for them to get here. They detained him. I didn't see them do that. The detective that's here came to talk to me. They told me to just hang out in my room and not come out. And so within 20 minutes, I guess.
Do you see the person who threatened you on September 28, 2023 in the courtroom here today?
I think.
Is that, can you respond verbally, please? Do you see him?
Maybe, yeah. Is that D? We only met like, we weren't friends. You know, I barely remember what he looks like. I'm not gonna lie to you.
Were you pointing to the defendant, DeMarcus Tate?
Yeah, right there.
Okay. Is that the man who threatened you?
Yeah.
If I could have just one moment, please. Oh, no more questions, thank you.
All right, cross-examination?
Thank you, Your Honor. Good morning, Mr. Coulson.
Morning.
So I'm just gonna ask you some follow-up questions about what Ms. Mulligan already asked you. Okay? So, you said that when you called the police to report a theft, that you reported DeMarcus Tate as a suspect.
Mhm.
At that time, did you know his name as DeMarcus Tate, or did you name someone as D?
Yeah, he gave me his name as D. I found out his name, DeMarcus Tate, from the police.
Later on, after all of this happened?
Mhm.
So at the time that you made the call to the police about the theft, you had said that it was someone named D?
Yep.
Okay. And then, when you were talking to the police, so they came up, you said they had already arrested him by the time they came to talk to you, right?
I think so.
Okay.
Yeah.
And then, when they were talking to you, there was a little bit of a disagreement with the detectives, right? You said that they told you to stay in your room but that wasn't necessarily what happened, was it?
Can I explain what happened?
Sure.
My neighbor Valencia, she got paranoid that they were gonna investigate her, because she was the other person that was in my room. There was only 2 people that had entered my room from the neighborhood, Dee
Okay.
and, Valencia.
But with respect to you, what did you do that caused that disagreement with the police officer?
He told me that I should stay upstairs in my room. I didn't know it was like an order,
Okay,
so I tried to go outside and see what they were like talking about, and he
okay,
basically made me go back to my room.
okay. And they had to bring you back to your room?
Mm-hmm.
Okay. And you had told the officer that Valencia was bad talking you to the police?
Yeah, she lied and said that I was like violent or something. She kind of
Okay.
messed up a little.
Okay, and so you were upset with what she was telling the police, so you went over to try to be involved in the conversation?
No, I wasn't upset. I just wanted to see what was happening.
Okay, and then he brought you back to your apartment and told you to stay there?
Mm-hmm.
Okay, and then when the detective came to talk to you afterwards, you had told him that you thought Valencia also could have been someone that took that money from you.
Only because she was the only other person. I actually thought it was a very low chance, like less than 1% probably.
Okay, so you spent probably a couple minutes talking about that theft with the detective, right? Before talking about any threats, you were talking about the theft of the money?
Yeah.
Okay, and then when you were talking about that, you had said at first you thought it was DeMarcus, then you thought it was Valencia, and then the detective said, well, you don't really know who it was, do you? And you said, right.
My intuition told me it was DeMarcus.
Okay, but at that time, on that date, when you were talking to the officer, you said you thought that it also could have been Valencia. You thought it was suspicious that she was getting so defensive.
Yeah, 'cause she kind of turned on me, so I was like, that's weird. Maybe,
Right.
I don't know,
So
maybe
you
she
thought
took it.
maybe it could have been her because of how she was acting.
But I think she just flew off the handle. I don't think she took it.
Okay, you thought she was flew off the handle because of what she was telling the officers about you?
Well, I don't want to rat her out, but she smokes cannabis, so I think she was afraid that they were gonna go into her apartment and find it. So she
Okay.
kind of like bad talked me because of that.
So you thought that she was talking bad about you to throw off suspicion from
Yep.
herself? Okay.
Yeah, so.
Okay. And then, you said when the prosecutor asked you if you believed that he was gonna harm you, you said you didn't know whether you believed it or not, but you didn't wanna risk it, right? And that was why you called the police?
Yeah, I didn't know. But, there are gangs in Cleveland, and
Okay.
I know someone who's in the Heartless Felons, and they do kill people, so
Okay.
that's why I called the
And
police.
you had told the officers that you also believed that Valencia's boyfriend was in a gang, right?
My friend Jeff said that he saw a tattoo on him that indicated he might have been.
Okay.
That was why I thought that.
So you had brought that up in the conversation with the officers as well?
No. No, I didn't mention that to them.
Okay. So you didn't mention anything about Valencia's boyfriend being in a gang? Or just not how you knew?
I don't remember doing that, no.
Okay. So, after this incident happened, the officers came to talk to you, you said it was about 20 minutes, the whole interaction?
Maybe a little longer, yeah.
Okay. Do you remember telling the officers that your neighbors had heard everything as well?
I don't think I said that.
Okay. Do you remember specifically telling Officer Blackstone that one of your neighbors downstairs was right outside as it all happened?
Allison, yep, she came outside during it.
Okay. And anybody else besides Allison?
No, I don't think so.
Okay. All right. One moment, please. I have no further questions, thank
All
you.
right, any redirect?
No, Your Honor, thank you.
You may step down, thank you.
Thank you.
All right, next witness.
State calls Detective Gabriel Slay.
Will you raise your right hand, please? You swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, have a seat.
Good morning.
Morning.
Would you tell everyone your full name, sir,
Gabriel Slay,
and spell your last name for the record?
Sleigh.
And what is your occupation, Mr. Slay?
I'm a detective for Willoughby Police Department.
How long have you been with the Willoughby Police Department?
Since 2011,
And in what capacity have you served that community?
as a patrol officer and as a detective,
How long have you been with the detective unit?
since 2019.
And can you briefly describe your background, your training that qualifies you for the position?
Yeah, I have a bachelor's degree in criminal justice from Kent State University. I graduated from the Basic Police Academy from Lakeland Community College in 2008. I've taken hundreds of hours of continuing education courses throughout my career as a police officer. In 2018, I received a certificate as a Master Criminal Investigator through Ohio Peace Officer Training Commission.
Now, in your work in Willoughby, you're familiar with the apartments on Fox Run Drive,
I am.
correct? Can you describe what that apartment community is like?
Yeah, so Fox Run Apartments, it's now called the Hamlets, it just changed ownership. It runs off of Lost Nation Road to the east, basically goes straight back east. There's about 24 buildings in that complex. And each building probably has close to 8 apartments, I believe, two stories.
And they're brick buildings, or they,
I think they're brick and they have vinyl siding.
and are they situated close to one another or
Yeah,
spread out?
yeah, they're close to each other.
Okay, specifically going to 1345, that building that contains apartment 207 where Kevin Corkin lives. Are you familiar with that building?
1343, yes.
1343. There is a 1345 though, isn't there?
Yeah, it'd be the next, basically the addresses increase in number as you head east. So 1343, and then the very next building is 1345.
And how much space is there between 1343 and 1345?
40 feet, and just estimating.
And these buildings are in Lake County, Ohio, correct?
Yes,
Now, going to September 28th, around 3 o'clock in the afternoon, do you remember where you were around that time?
yes.
Where were you?
I went to the leasing office at Fox Run Apartments.
Okay. And were you with anyone?
Yes, my partner, Detective Burrington.
Okay, and that's Detective Burrington, who's sitting at the trial table here today?
Yes.
And what was the reason for going there?
We were following up on a case we were assigned.
Okay. And you saw Kevin Corkin come out of the courtroom?
Yes,
Okay. Did he report a theft then?
he did.
And was that what you were investigating?
Yes, it was.
Now, you went to the leasing office with Detective Burrington. Did there come a time that there was a call to direct your attention elsewhere?
Yeah, we were only there for about 5 minutes, and we overheard a radio call from our dispatch center that Mr. Corcoran reported that he was threatened by an individual while he was at his apartment, and we responded from the leasing office to Mr. Corcoran's apartment, it's only about 100 yards away.
Did both of you go?
Yes.
And were you the sole police response to this?
No.
Okay. Who else came?
After just almost immediately after, me and Detective Burrington arrived, Patrolman Blackstone, came to the apartment.
But you and Burrington had gotten there first?
Yes.
And were you in uniform?
No, plainclothes.
What about Detective Burrington?
Same.
Plain clothes?
Yes.
Officer Blackstone?
He was in patrol uniform.
And do you know how Blackstone got there, if you know?
Police cruiser?
What did you do when you got into the building where Kevin Corcoran was living?
My partner talked to, Mr. Corcoran, and got details about the threat that was alleged. And also a neighbor right across the hallway was spoken to who corroborated what Mr. Corcoran said.
And did Mr. Corcoran give you an idea about who it was that had threatened him?
Yes, we were able to determine it was DeMarcus Pate who made the threats.
Okay. And did you know or have any idea at that point where to find DeMarcus Pate?
Yes, building 1345, apartment 107.
So after the conversations of the three officers with the individuals there near Kevin Corcoran's apartment, what did the three of you decide was the next course of action?
We went over to apartment 107 in building 1345, knocked on the door to that apartment. The door was answered by a female. We asked to speak to Mr. Pate. Mr. Pate came to the door, and at that point we placed him under arrest.
What did you arrest him for?
Making threats to Mr. Corcoran.
And what happens when police officers make an arrest of an individual person?
After they're secured in handcuffs, we search them for contraband.
And did that happen?
Yes.
Where did that happen?
Right in the hallway in front of apartment 107.
And you say you search them. How is that search actually effective?
Basically, an officer takes their hands and pats them down, feeling for any objects in pockets, and if there is something, the object is removed.
And who patted down, did somebody pat down Mr. Pate?
Yeah, Patrolman Blackstone.
Okay. Were you present when that happened?
I was.
Okay. And what, if anything, was retrieved?
In Mr. Pate's right front pocket, a bag of white powder in a sandwich bag was located.
What happened to that powder in the sandwich bag?
Patrolman Blackstone handed it to me. We then walked Mr. Pate out to a cruiser, and Officer Rastel was standing by with the cruiser. I handed the bag to Officer Rastel, and then he put it into a evidence bag, I believe.
Now, in the Willoughby Police Department, do the uniformed officers wear body cameras?
They do. Or no, sorry, some of them do, but a majority of them do not.
It is not standard issue for a Willoughby police officer to have a body camera?
That's correct.
During this interaction, did you, or if you're aware, Detective Burrington, have any recording device that was activated?
No.
What about Officer Blackstone? Did he have any recording device that was activated?
He did, yes.
Okay, and what is that?
So our dash cam systems and our cruisers, they have a microphone that the officers attach to their uniforms, and it's like a remote thing, so like a wireless. So as they walk around, their voice is recorded, even though the camera's not with them.
And is it relayed back to the cruiser itself?
Yes.
And are you aware of whether or not that was employed during this particular incident?
It was.
And speaking of incidents, how does it work with the police department when a call comes out? How do we know which call we're talking about, weeks in advance or years in advance?
Each case is assigned a report number.
And that is unique for each case?
Yes.
And this case has a unique number?
Yes,
So then it's possible to get the recordings from a particular event as well.
yes,
And are you aware of the recording from Officer Blackstone's cruiser?
yes,
And the recording would have, the part that he was with you, would have picked up your voice as well.
yes, if I was next to him.
When you arrested DeMarcus Pate, did he say anything about what you found in his pocket?
He did.
What did he say?
He said it's powdered sugar.
If I may approach?
Yep.
Showing you what's been marked as State's Exhibit 2. Do you recognize that?
I do.
What do you recognize it to be?
This is a recording of Patrolman Blackstone's dash cam.
And you've seen that before?
Yes,
Have you seen what's on it?
yes,
And you know it contains just the parts that you were witness to?
yes.
And you know that because,
I reviewed it.
with the court's permission, I'd like to play the disc.
Any objection to the admission of Exhibit 2?
No, Your Honor.
All right, it's admitted, you can play it.
Pause it, thanks. I'm gonna pause it here just so we can get a perspective on what we're looking at. If you would, what are we seeing in that picture?
This would be the cruiser facing east, and that the building is 1343 Fox Run Drive.
We're looking, and who was living in that building, you know?
That was Mr. Corkin's building.
Okay. And is that the building that you went to first?
Yes,
Okay. And what did you do in that building?
just talked to Mr. Corkin.
And about how long were you in that building?
Only a couple minutes, or if that.
And after you made the decision to go find DeMarcus Pate, where did you go?
To the building right next door, 1345.
And if we're looking at this picture, where would 1345 be?
Right behind it.
Okay. Would you have to come out the door that we're looking at to get to 1345?
No, so if you walk in that door, and kept walking straight, there's another, like a back door that would go straight. If you walk out that door, you go straight into the front door of the door of 1345.
And is that what you did?
Yes.
Okay, you can play it. We hear voices. Do you know whose voices those are?
I believe that's Patrolman Blackstone's and possibly mine.
Okay. Are you able to discern what words are being spoken?
I'm not.
Okay. We hear sort of a female voice. Are you aware of who that might be?
That's either the neighbor who came out, Mr. Corkin's neighbor, or possibly Mr. Pate's sister.
Okay.
But I'm not sure, I couldn't tell you for sure.
Not sure where we are in this process? Okay. The whole thing is about 8 minutes long. With a little patience, we'll get there. Thank you.
Who called me, bro? I literally just came back. I stopped over there to talk to my shorty, and I came back. I don't care, you can test that, that ain't no... Dude, that ain't nothing. Powder search. Go ahead. That ain't no drug.
We see people walking there. Who do we see walking?
That is me and Patrolman Blackstone and Mr. Pate walking to the cruiser.
Hold on. Pause that. Ask that question again, because he couldn't be heard.
Okay. We see people walking over there on the left side of the screen. Who is that walking?
That is me, Patrolman Blackstone, and Mr. Pate.
The arrest has already taken place.
Yes.
Y'all didn't have a warrant or nothing to come in. Y'all didn't, I didn't get no permission to search or none of that. I didn't get nobody's permission to search me.
Do you know what officer that is and what cruiser that is?
That is Patrolman Rastel. I'm not exactly sure the cruiser number. I can't see
That's all right. But that was the cruiser that he came in, you believe?
it. Yes.
I'm not sure. Yeah. Oh, look, I ain't getting nothing wrong. Yeah, y'all found the bag.
Sir, what is happening right here?
I handed the bag of powder to Patrolman Rastel. I believe now he's getting an evidence bag to put it into.
Okay, what is the procedure there as far as the evidence goes?
So we put it into an appropriate package, transport it back to the Willoughby Police Department, and then it's labeled, and then entered into evidence. And then in this case, if it's narcotic or suspected drugs, we request that it be sent to the Lake County Crime Lab to be analyzed.
If I may approach?
Yep.
I'm going to show you what's been marked as State's Exhibit 3. Do you recognize that?
I do.
What do you recognize it to be?
This is the suspected drugs that we got from Mr. Pate that day.
Okay, how is it that you know it to be that?
It's labeled by, or it was sealed and labeled by Patrolman Rastel. It's got the case number, the date, and the evidence number on it.
And is it in substantially the same condition as when you retrieved it from Mr. Pate?
Yes.
The video that we have just seen, does that fairly and accurately depict what took place in your presence there on September 28th, 2023?
Yes.
And do you see the man that had the powdered sugar in his pocket here today?
I do.
Would you point him out? The record can show that he is identifying the defendant.
Why don't you describe his clothing for me?
He's wearing like a gray button-up shirt or white button-up shirt.
All right, the record will reflect he's identified the defendant.
And is that the man that you arrested for the aggravated menacing?
Yes.
I could have just a minute, please. I don't have any more questions.
All right, cross-examination?
Thank you, Your Honor. Oh, thank you. Good morning, officer.
Morning.
Okay, I'm gonna start kind of from the beginning. So, you said that when you got there, you were not the only officers, you and Detective Burrington were not the only officers that arrived, that also, Patrolman Blackstone arrived?
That's correct.
Okay, and Patrolman Blackstone was the one who predominantly spoke with Mr. Corkin about the incident, right?
I believe it was Detective Burrington.
Detective Burrington? Okay. And did you talk to any of the neighbors personally when you were there?
Other than small talking and overhearing what the other officers were saying to them, no.
Okay. And so you didn't talk to any potential witnesses about the incident?
No.
Okay. And then, do you know which neighbor you said you just had small talk with? Do you know which neighbor that you had small talk with?
Her name was Miss Watkins, and I believe she lived in 1343-205, which is directly across the hallway from Mr. Corkin.
Okay. Do you happen to know her first name?
I can't think of it right now, no.
Okay. And you said that some officers do wear body cameras, but most in the Willoughby Police Department don't, right?
Correct.
Under what circumstances do officers wear body cameras?
If they decide to buy one themselves and wear it,
Okay, so you did not make that choice to buy one yourself?
that's correct.
Okay. And you said that you were in the building that Mr. Corkin lived in for a few minutes before you went over to the apartment building that Mr. Pate was apprehended in?
Yes.
Okay, and in those few minutes, you said you made some small talk with a neighbor, but didn't talk to anyone about the allegations of the threat?
That's correct. Detective Burrington and Officer Blackstone were taking care of that.
Okay. And at some point in the video, you hear someone saying, Kevin, we're trying to get him. Presumably that's referring to, they're trying to get Mr. Pate?
I would assume so, yes.
Okay. And was that you that stated that, or was that one of the other officers that was present?
I couldn't be sure.
Okay. And that video that was played, those 8 minutes, you said that fairly and accurately depicted what took place in your presence, but that whole investigation that day didn't end there, right?
No.
You were on scene for another half hour to an hour after that?
Yes.
Okay. And then when after Mr. Pate was put into the cruiser and you passed off the suspected drugs to Officer Raxel, you went back into Mr. Corkin's building, correct?
Yes.
Because you were following up on the theft allegation, right?
Yes.
And that was with Detective Burrington as well?
That's correct.
Okay. And at some point, you were speaking to a neighbor by the name of Valencia?
If that's Miss Watkins, yeah, we did speak.
You were talking to a neighbor about the theft incident, correct?
Yeah, I'm assuming so, yeah. I can't specifically remember what was said, but that's the purpose, why we were there, is to investigate the theft, yeah.
Okay. And no charges for that theft were ever filed against Mr. Pate, correct?
That's correct.
And during this incident, after the fact, was it Officer Blackstone, or you said you thought it was Officer or Detective Burrington that talked to Mr. Corkin?
I believe Detective Burrington spoke the most, because we were following up on the theft, so it was kind of our purpose to be there. So not only was he asking about the threats made, but also trying to gather more information on the theft.
Okay, but you weren't present for that discussion?
I was present, yes.
You were present? Okay. Do you recall a time during that where, Mr. Corkin was asked to go back to his apartment and actually had to be physically removed back to his apartment
Yes,
because of an interaction with the neighbor,
yes,
where he was interfering with the investigation?
I do.
And he was upset about the fact that he believed that that neighbor was talking bad about him?
I don't remember the exact reason why he was upset, but yes, I do remember him being upset.
Okay. And then, do you know if there were any other neighbors that were talked to after this incident? That, Patrolman Blackstone would have talked to a neighbor after the fact?
You'd have to ask Mr. Blackstone, I can't recall.
Okay. So you specifically did not have much to do with this menacing situation?
Yeah, I was there more or less in a backup capacity.
Okay. And after this incident resolved, once, I'll say resolved, but once Mr. Pate was in custody, witnesses and Mr. Corkin had been spoken to, both you, Detective Burrington, Patrolman Blackstone, and I believe Patrolman Raskell all converged to discuss the incident, correct, outside?
That sounds accurate, yes.
Okay, and at that point, you determined that no charges were going to be filed for the missing, that he was in fact going to be charged for trespassing?
I don't believe that determination was ever made, no.
Okay. So it was your understanding when he left that he was going to be charged with menacing?
Yeah, the reason we arrested him, myself and Detective Burrington, was for aggravated menacing.
Mm-hmm. And it was your understanding that from that point going forward, that that was going to be the case?
Yes.
Okay. I have no further questions, thank you.
Any redirect?
No redirect.
All right, you may step down, thank you. Next witness?
State calls up, Patrolman Raskell.
Will you raise your right hand, please? You swear testimony about gives the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, have a seat.
Good morning.
Good morning. Good morning.
Would you tell everyone your full name, sir,
Kevin Raskell,
and spell your last name for the record?
Rastall,
And your occupation, sir?
patrolman with the city of Willoughby.
How long have you been a patrolman for the city of Willoughby?
It's been over 7 years now.
And can you briefly describe your background and your training that qualifies you for the position of patrolman in Willoughby Police?
Yeah, so I graduated the police academy at Kent State in 2009, began my career in East Cleveland, went to Painesville City Police Department, and then, now I'm here in Willoughby Police Department.
Okay. And you've been Willoughby how long?
Over 7 years now.
And how long have you been a police officer?
Oh, it's been 12 years now?
And you are a certified peace officer in the state of Ohio, correct?
Yes.
Going back to September 28th, 2023, were you working that day?
Yes, I was.
And were you in uniform?
Yes, I was.
And were you in a cruiser?
Yes, marked cruiser.
Marked cruiser. Do you fellows go two to a car or one to a car?
One to a car.
Did you get called to the Fox Run Apartments in the afternoon as a backup?
Yes, I did.
What did you understand you were backing up to?
There was a call that a gentleman had been threatened at the apartment building, and by the time I had arrived, there was already officers on the scene.
And as backup, what is your role when you get there?
Just to make sure that they're safe and anything they need assistance with, just to help them out.
Okay. And during the course of that call, did you encounter Detective Gabriel Slay?
I did, yes.
And did he give you anything?
Yes, he did.
What did he give you?
He gave me a baggie of white powder.
And what did you do with that baggie of white powder?
I secured it in the back of my cruiser.
And when you say secure, what does that mean?
I actually put it in a bag and then put it in, one of the, we have bins in the back of the cruiser.
And you understood that to be evidence, correct?
Yes, I did.
Okay, what's the protocol when you receive a piece of evidence? What do you do?
So we take it back to the station and, package it. In this case, it was powder. So there's certain procedures you have to follow with that. It needs to be double bagged in plastic, and then sealed with tape on any open end and then initialed.
Okay, I'm gonna hand you what's been marked as State's Exhibit number 3. Do you recognize that?
I do, yes.
What do you recognize that to be?
The powder that Detective Slay handed me.
Okay. And was there anybody else present at the time that Detective Slay handed that to you?
Believe the suspect was present
Who is
and
the suspect?
DeMarcus Pate.
Do you see him in the courtroom today?
I do.
Would you point him out, please?
He's right there.
What is he wearing?
Light purple shirt.
If the record could reflect that he has identified the defendant.
It shall reflect.
Okay. How do you know that to be the same cocaine that you got on September 28th?
Because I labeled it.
Okay. And how did you label it?
With my initials across the top, the case number, the date, and the item number, which tells the crime lab what item number within the series it is for the
Okay,
case.
the case number. Tell us about the case number. What is that?
The case number is the case number for the call that we go to that becomes the report, and it uses the same number throughout the whole process.
Okay, and what else does that number appear on?
So the report, it appears on the lab sheet that we send with the evidence to show that this is the report that it belongs to, and it appears on the evidence, so we keep track of everything that way.
Is that how you make sure everything is in the right place?
Yes.
Okay. And when you put your initials on it and you put the case number on it, where were you, if you recall?
At the station.
What happens then after you do that?
Once I do that, we have a drop box through a locked door that we drop, or I'm sorry, the evidence goes into a locker that requires a key. So then you lock it with the key, then you take the key and drop it in the lockbox, and that's behind a door that I don't have a key to.
Okay. Where does this key come from?
It stays in the locker, so you know that that one's empty. You can put your stuff in it, take the key. It's much like the lockers if you, at a public place that you can use or rent.
Okay.
So it has that key, you pull it out. Once it's pulled out, it's locked, and then you drop it in.
And then you drop the key where?
It's like a mail slot in a door, but that door is locked and I don't have access to it.
Who does, do you know?
I know there's several people that do at our department. I know our detective lieutenant has access to it, and there's also another evidence custodian that has access to it.
Okay. So just any old patrolman can't go in and say, hey, let's see what's in the
Right.
evidence locker?
Right.
Okay.
Right.
And any old detective can't do that either, right?
As far as I know, right.
What's your understanding of when you gather a piece of evidence, what happens after you put it into the locker?
If it's a piece of evidence that needs to go to the crime lab in Lake County, one of the custodians that has access to it makes notes in our computer, then takes that piece of evidence and transfers it to the crime lab, and then the crime lab signs for it, and then eventually it'll get tested if it needs to be tested or whatever the process is after that.
Okay. Is there anything on that item that you have in front of you that indicates that that took place with this particular piece of evidence?
Yeah, so there's a red piece of evidence tape on the bottom that indicates the crime lab opened it to test it.
Okay. And is there anything else on there that indicates the crime lab had it?
There is a crime lab, a barcode on the back that they keep track of for their records.
And is that aside from the markings from the lab, is that in the same condition as it was when you packaged it and received it on the 28th of September, 2023?
Yes, it is, yes.
Nothing further, thank you.
Cross-examination?
Thank you, Your Honor. Good morning, officer.
Morning.
So, after this incident, did you write a report?
I did not.
Okay, do you know who did write a report?
Several people, I believe. Detective Slay wrote a supplement. I'm not sure, but I think Detective Burrington did, and Officer Blackstone, I believe, did as well.
Okay, and you interacted with Officer Blackstone quite a bit, right, on the state?
Not for very long, no.
Okay.
At the scene, I'm
At
saying.
the scene,
Yeah.
right. So, when you arrived, they were already bringing out Mr. Pace, correct?
Yes.
And at that point, then Officer Blackstone and you talked for a little bit while the detectives went back inside.
That's possible, yeah.
Okay.
I don't remember if,
Okay,
what we
and,
talked about.
from your understanding, which officer talked to Mr. Corkin on this date?
No, I'm not real sure which one talked to him.
Okay, do you remember speaking to Officer Blackstone about what Mr. Corkin had reported?
Vaguely, so I'm assuming he must have spoken with him.
Okay,
But I don't know if he got that from a different, one of the detectives or,
okay, so you didn't speak to Mr. Corkin at all during this
no,
interaction?
no,
Okay, you did speak with Mr. Pate though, because he was in your cruiser?
yes. Mm-hmm.
Okay, and before you left the scene, or when you did leave the scene, you were leaving to take Mr. Pate to the Lake County Jail, correct? Or to the Willoughby Police Department?
Yeah, I believe we took him to the Willoughby Police Department first, to the
Okay.
jail there.
And at that time, you told him that he was only being charged with trespass, that there were no other charges at that time?
I don't remember.
Okay. If I played some of the video from you had a recording on your cruiser that day,
Yeah,
correct?
mhm.
And that records the audio?
Should, yeah.
Okay, so there's a video portion and an audio portion?
Yeah.
Okay, so,
Your Honor, I'm gonna object as to the relevance.
you to go back to the jury room at this time. It should be only for a short period of time, then we'll get you back, okay?
All right. Seriously, will call me back.
Okay, have a seat. Ms. Carroll, go ahead.
What do I have to do to switch it? Thanks. Does this scene look familiar?
Yeah,
Okay,
it does.
so I'm going to play, from minute 30, actually gonna go up to 30:30. Not sure how loud that's going to be.
Wait. Stop that.
I am.
You indicated to me that you're trying to refresh his recollection as to whether he said Mr. Pate was gonna be charged with trespass or menacing, right?
That, as well as the fact that there was a conversation about it beforehand.
Well, ask your question and predicate to that first, again,
Ask my question to the witness.
to the witness.
Okay, so do you recall there being a discussion about the incident with the detectives and Officer Blackstone?
I do now.
Okay.
Okay.
And do you recall what was determined in that conversation?
I don't recall.
Okay.
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 Would that help refresh your recollection if she played you that clip?
I'm sure, it- yeah, I'm
All
sure I
right,
would,
go ahead
yeah,
and play
it's
it.
just been a while and.
Go ahead and play it.
Understandable.
Over here.
Dude, I always mess those up.
If I leave it, I usually have it on.
Yeah. But it's the color, right? It's the color.
Hold on.
Yeah.
Are we getting to somewhere where it discusses whether he's gonna be charged? I don't wanna play the whole clip. I wanna play the
Yeah.
pertinent parts that are relevant, that refreshes recollection.
We have even Owen has on it. Yeah.
Okay. So there, do you recall turning off the audio recording on your?
Wait,
Yeah.
you asked him whether he had a discussion.
Yes.
He said he didn't recall.
Okay. Does this refresh your recollection of what that conversation was about?
No, I don't remember what we talked about necessarily, but I remember having a conversation, we obviously had a conversation, I don't remember what it was about, to be honest.
Okay. And then I'm going to skip forward to conversations that you had with Mr. Pate.
Okay.
You stated you didn't remember talking to him about what the charges were going to be.
I remember talking to him about it, I don't remember the
What you had
substance,
said.
right, yeah.
Okay. So I'm going to go to 34 minutes and 54 seconds.
I'm still, registering, the objection as to the relevance of this whole, what he told Pate, and are we gonna bring in what his Pate's statements are, that's.
Well, we're gonna find out, 'cause I
Okay.
don't know what the evidence is. You guys do, I don't. So let's find out if it refreshes his recollection, then we can talk about the relevance of those discussions.
Okay, it might take a second to load. Try to reopen it.
Oh, no.
Sorry. Let me try a different way. I don't know why this is not playing. we just ask for a brief recess to try to get this loaded?
All
I'm
right,
fine
well,
with everyone sitting here, I just don't wanna take up.
let's assume for a minute that on, I think you said 3 different occasions, that there's a discussion between the patrolman and Mr. Pate about what the charges were going to be. Let's assume that, you gotta put your hand down, you gotta put your hand down. I'm not gonna call on you, you gotta put your hand down. Let's assume for a moment that there was a discussion and Patrolman Rastel, in response or on his own, said, we're not charging you with aggravated menacing, we're charging you with trespass. Okay. So let's assume that that's on there, and he says, yeah, my recollection is refreshed. Okay. And the jury comes back in and says, and you say to Patrolman Rastel, didn't you on 3 separate occasions in the patrol car say to Mr. Pate that you were only gonna be charged with trespass and not aggravated menacing? And he says, yes. Where is the relevance there?
The relevance is that Officer Rassel was not the one that did investigate the menacing.
Okay.
He spoke with the 2 detectives and other officer that did investigate the menacing, and after a discussion where the audio was turned off, he came back to his cruiser and stated multiple times to Mr. Pate that he was only going to be charged with trespassing, that he was not going to be charged with menacing.
Okay, and so then, that means what with regard to this case?
That after the investigation that was done by these officers, they determined that menacing was not an appropriate charge for what had occurred. After speaking with witnesses and the alleged victim.
He had been arrested for aggravated menacing, correct?
That, as multiple officers came here for the suppression hearing, they stated that he was arrested for trespassing.
Okay. He was arrested, was he not?
He was arrested.
Okay. Now, if you're arrested for one charge, you can be subsequently charged with another offense, right?
You can be.
After any further investigation?
Yes.
Okay. Whether he was arrested for trespass or anything else, as a result of the arrest, he was patted down, correct?
Correct.
And that's when the powder was found, correct?
Correct.
Okay, so where's the relevance to this?
This is not for the possession charge. The relevance is for the aggravated menacing charge.
Okay, but still, he can be charged, he can be arrested for disorderly conduct and subsequently charged with something
He can be.
more restrictive, right, or more severe, right?
He can be, but the fact that the officer talked to the other officers that investigated the case and they came to the conclusion that he was not going to be charged with aggravated menacing that time does make it more likely that, or less likely, that an aggravated menacing did occur.
Why? Why does it have any bearing on whether it's more or less likely?
If the officer spoke to the alleged victim and 2 neighbors
Right?
about the incident and then determined that they were not going to charge him at that time,
So if the determination is made on scene that somebody's gonna be charged with a particular offense, they're stuck with that from there forward through the entire prosecution?
no, they're not stuck with that, but that does make it less likely that that happened when
That-
we
that what
also bring in
happened?
testimony that an aggravated menacing happened.
Okay, this isn't relevant to this case. They
So-
don't, no, well,
Your
we're not
Honor,
gonna
can I
go.
please speak,
We're
Your
not,
Honor?
no, you may not speak, okay? And and what I tell you this morning before we started, you have a lawyer, your lawyer speaks. If you're gonna speak out of turn, you're gonna remain in the other room for the balance, okay? So the recollection refreshing has no bearing on the charges. So it's not relevant, it's not coming in. Bring the jury back in. You can continue your examination of Patrolman Rastel.
All right, the jury.
All right, be seated. Ms. Carroll?
I have no further questions, thank
All right,
you.
any redirect?
No, Your Honor,
All
thank
right,
you.
you may step down, thank you. Bob, come here.
After,
All right, ladies and gentlemen, we're gonna take, our lunch break right now. I'd like you back at about 10 minutes after 1 to begin again with the next witness. Remember not to discuss the case among yourselves or with anybody else. Don't, try to find out any information from any other source, and do not come to any conclusion until the case has been given to you for deliberation. We'll see you in an hour and 10 minutes, okay?
All right, so jury, jurors, can you just back to the jury room for me?
Have a seat. Once, Bob comes back, they're gonna take Mr. Pate down. You taking him downstairs? All right. And then I'll have him release a jury so they're not crossing paths, okay? So just sit tight for a minute. Okay, they're in there? All right, go ahead. All right, sit down a minute. There has, been some discussion about juror number 5 that I know Mr. Pate has had with, Nicole. What do you want to do with regard to juror number 5? Who, keep in mind, is designated as the alternate at the end of this whole thing.
Yeah, I mean, at this point, I don't know. I would like to at least have her spoken to about the
Spoken,
necessity of staying awake during the trial.
okay.
I mean, at this point, we can't really bring in another juror if they've already missed.
Well, we have an alternate. We have 13
Right, she
jurors.
is the alternate, right, which,
Okay.
is why at this point, it may not be an issue if
Okay.
she is in fact an alternate when it's over, but I would at least like something said to her about the necessity for staying awake during the trial.
Mulligan?
Perhaps if we need her as an alternate?
All right, bring her in.
Want to release the rest of the lunch?
Yeah. You just grab that first chair if you like. The reason I brought you back in is that I've noticed, on probably 4 or 5 occasions that you've nodded off this morning during the trial. All right. I mean, has that happened?
Probably,
Okay. And I know you're,
it's just the condition, yeah.
right, so I know that plays into it, and you've probably had some, difficulty with the advanced pregnancy of getting all the sleep you want, but I think at this point, you know, for your benefit as well as everybody else, I think we'll just excuse you, and then you're all done then.
Thank you.
Okay? That's all right. Okay, so Bob will he'll you know, give that to him when you go back through that door, okay? All right, thank you, Ms. Tankersley. All right. All right, so there is no alternate. You have one more witness?
One more witness.
Do you have any idea what you're doing with regard to witnesses?
The only witness we may potentially have is Mr. Pate.
Okay.
We'll have a discussion about that with him.
Okay, have a discussion, having him keep his hand down, because we're not in school, and look, I mean, if I stayed true to my word, I would have had him removed then, okay?
I do
So
understand.
have that discussion, okay?
Will do.
All right.
All right.
And during the these haven't been admitted, so you don't have custody of that.
You can just leave them here. Do you have a plan? Yes, I will lock that, or we'll take it. I will talk to him because.
Are they not admitted even though they've been published?
They're not admitted until.
Until we ask?
Yeah,
Okay.
these are kind of, yeah, when they do publish, I sort of take that as a nit, but.
I kind of,
definitely-
okay,
But
all right.
This is a whole different ball of wax. And I'm too sour sleeping, and I never say a word, and I get up and I'm like, that shit pisses me off, I glare at her, I glare. Get one, glare. There's a couple other ones, I'm like, yes, I can do, but, you know, you can close your eyes, you know, you can't.
Yeah.
You can lock it up right now.
Yeah.
This is very nice.
I guess so.
We don't need it anymore.
I don't really need it.
And we don't need it anymore, so if you just want to take it back.
Yeah, that's true.
Right?
Yeah.
It's just still. And on PowerPoint.
Swear testimony about gives the truth, the whole truth, nothing but the truth, so help you God. All right, have a seat.
Hello. Could you introduce yourself to the jury and spell your last name for the record?
Yes, my name is William Kubek, that's Koubek,
Where are you currently employed?
at the Lake County Crime Laboratory.
What's your job title at the Lake County Crime Lab?
I'm the supervisor of chemistry and toxicology,
And how long have you been employed there?
a little over 10 years.
And what are your duties?
I manage the day-to-day operations and the personnel of the controlled substance sections and toxicology section as well. I also complete casework from time to time.
What education and training you have to qualify for your position?
I have 2 bachelor's degrees from Tiffin University. The first is a Bachelor's of Arts in General Science that's focused in chemistry. The second is a Bachelor's of Criminal Justice in Forensic Science.
Do you complete continuing education in your role?
I do.
And can you describe what that is?
Yes, continuing education is essentially workshops or seminars or conferences that we go to or we can go to on a rotating basis. We are not required, at least in my sections, we are not required to perform continuing education on a yearly basis, but it is highly encouraged to do so. So I will go to an annual workshop or seminar every year, in addition to webinars on a weekly or monthly basis.
And can you explain what the Lake County Crime Lab is in general?
Yes, it is a full-service laboratory that performs testing on pieces of evidence from law enforcement agencies. So we perform testing on DNA, fingerprints, trace, controlled substances, toxicology, and firearms.
Can anyone bring items to the lab to be tested?
No, just law enforcement agencies.
Is the Lake County Crime Lab accredited?
Yes.
What does that mean?
Accreditation is a voluntary process that the laboratory goes through to show its commitment to quality and consistency in the work product that it produces. So to become accredited and to maintain accreditation, we go through a rigorous audit every 4 years. And this entails a team of forensic scientists coming into the laboratory and assessing us against the 300 or the over 300 requirements placed on us by our accrediting body. They look at everything from personnel to procedures to instrumentation and everything in between. Every facet of what we do is thoroughly checked against those requirements, and we have to meet every single one of those to become accredited. That happens on a 4-year basis, and as long as we meet all those, we maintain that accreditation, and then each year between that 4-year cycle, we have surveillance visits to where, again, another, not a full team, but 1 or 2 scientists will review our procedures and things like that to make sure we're maintaining that accreditation.
What's the lab's procedure for receiving evidence?
When a law enforcement agency wishes to submit evidence, they will bring it out to the laboratory and hand it over to our evidence custodians. The evidence custodians will then look over the evidence to ensure that there's a proper seal on that piece of evidence, which essentially means a tamper-evident seal across any point of entry into the evidence with the initials of whoever sealed it on that piece of evidence. If the evidence does not contain a proper seal, the evidence custodians will hand it back to the submitting officer, and they then have the option to either fix that improper seal right then and there and then resubmit, or they can take it back to the agency and resubmit it on a different day. If the evidence is deemed acceptable, the evidence custodians will take it in. They will then also start to create an electronic case file in our LIMS system, which is our Laboratory Information Management System. This is just an electronic database that houses all the information for all the case files that we create. So they will take the evidence submission form that the law enforcement agency creates and take all the pertinent information off of that submission form and place it into that electronic case file. As they're doing that, individual barcodes are being generated for each piece of evidence and then being placed on said evidence to associate that piece of evidence with this case. After that is all complete, they will then generate a physical case file that allows the analyst of the sections to know that there's a case that's been generated. Once that is all complete, they will then transfer that evidence into our locked evidence cage, where it'll be transferred into the sections bin, and it will await the analyst to retrieve it for work.
So, can you talk a little bit about the security of that room where evidence is stored?
Yes, so the room itself has a lock with a key code that only personnel of the laboratory are aware of, and then inside that room is a locked cage with another key code that only laboratory personnel. So there are 2 layers of security to get to the evidence itself.
Then what do you do when you receive evidence to analyze?
When I receive evidence, I will transfer it from that bin where it was waiting back to the section where I perform the work. I'll transfer it into my possession. I will write down the date and my initials when I perform that analysis. I will then open the packaging, but prior to doing that, I will ensure that the tamper-evident seal is still present on that evidence to ensure the integrity of it. Once I open the evidence, I will then perform my analysis. But prior to doing any work with instrumentation or finding the weights, I will perform quality controls on all of those things.
And then when you've concluded your analysis, what do you do with that evidence?
When I'm finished working on the evidence, I will place all the evidence back into its original packaging and then seal it with the proper seal. Transfer it from my possession back to the agency's bin in that locked evidence cage, where it will wait for the agency to come pick it up and take it back to their department.
With respect to this case, did there come a time when the Lake County Crime Lab received evidence from the Willoughby Police Department pertaining to DeMarcus Pate?
Yes.
Do you know DeMarcus Pate?
No.
As part of the DeMarcus Pate case, what evidence did you receive?
May I refer to my report?
You may.
I received one item of evidence, which was a plastic bag containing white powder.
I'm handing you with previous DeMarcus Pate Exhibit 3. Do you recognize that?
Yes.
How do you recognize it?
I recognize it by the individual barcode that was placed on the evidence by our evidence custodian. It has the initials of the evidence custodian, as well as my initials and the date of when I opened it, and my initials are across the tape, the seal here at the bottom.
And what is that?
This is item 1 for case number 23-1073.
Is that in the same substantially similar condition as when you first received it?
Yes.
And is there a barcode on it?
Yes.
And does that list the agency's case number?
Yes, it does.
What is that case number?
The agency case number is 23-36252.
And then, how was this item tested?
So this piece of evidence was tested by first opening the packaging and then taking the white powder out of all of its external packaging. There are, outside of this plastic bag on the outside, there are multiple layers of plastic bags on the inside. So I would remove the powder from all of those layers of plastic bags to determine a weight. That's what we call the net weight. So it's just the weight of the substance itself. Once I've generated or determined that weight, I will then take a small sample and perform FTIR testing, which is Fourier Transform Infrared Spectroscopy testing. This instrument uses vibrational patterns to identify unknowns. So I like to use the analogy of a guitar. When you pluck the string of a guitar, certain notes will be played based on the vibration and the tension in the string. So a G chord, given the tension on the string, will always be a G chord when you play it in that fashion. Based on how molecules are constructed and put together, they vibrate in specific ways. So cocaine will always vibrate in the same way, but vibrates differently than meth because it's made up differently, and which would vibrate differently than heroin. So I perform that test to identify any potential unknowns that are in this powder. After that testing, I would perform GCMS testing, which stands for gas chromatography mass spectrometry. This is 2 tests kind of smushed into one, where the GC portion of the test allows for separation of multiple components in a powder or a sample, and the mass spec allows for identification of those components. So again, I use an analogy for this, with the GC being much like a marathon race. All the runners start at the starting line at the same time, and once the race starts, based on their abilities and their experience, the faster, quicker runners will jump out to the lead and will finish the race first, whereas less experienced, less fast runners will finish the race last. This is the same type of theory behind the gas chromatograph. All the components will be put onto the GC at the same time. Then based on their chemistry, they will separate themselves out and complete the GC at different times. So meth will run through the GC much faster than, let's say, heroin or a pharmaceutical. So they will allow for separation. Once the GC is complete, it goes into the mass spec where the molecules are broken down and broken into pieces. And again, much like a jigsaw puzzle that breaks apart in the same way every time, molecules will break apart in the same way. All meth molecules will break apart in the same way as cocaine will break apart in the same way, but you can tell them apart from each other. So you can use those pieces to identify an unknown in a substance.
Does your analysis of items get memorialized in a final report?
Yes.
I'm handing you, would you recognize that report if I showed it to you in court today?
Yes.
I'm showing you what's the mark exhibit 4. Do you recognize that?
Yes, I do.
What is it?
This is a copy of the report for this case that I generated.
So this is a copy?
Yes.
Where's the original?
The original is housed in the laboratory in our LIMS system.
And when you created that report, was that near in time of your testing?
Yes.
Is this regular practice of the Lake County Crime Lab to keep reports?
Yes.
And is that a fair and accurate copy of your report?
Yes.
Do the practices that you utilize conform to generally accepted scientific principles?
Yes, they do.
Are you confident that the findings in your report are accurate?
Yes.
In this case, did you come to any conclusions about the presence of a controlled substance?
Yes, I did.
What was that conclusion?
That the white powder contained cocaine.
And did you weigh that powder?
Yes.
And what's the weight?
The weight of the powder was 26.51 grams.
And is that more than 20 grams
Yes.
and less than 27 grams?
Yes.
Are you able to tell right away whether that substance you tested was powdered sugar or something different?
Yes, I would be able to.
And how would you tell?
Using the techniques that I described earlier, the FTIR can identify pure substances very quickly. In less than a minute, that test is completed. And in this instance, the FTIR came back as cocaine.
What's the schedule?
The Controlled Substance Act of 1970 gave the DEA, or the Drug Enforcement Administration, the power or ability to group substances into what are called schedules. They're essentially just categories for substances that they evaluate. So Schedule 1 contains substances that have no accepted medical use and have the highest abuse potential or dependency potential. Starting in Schedule 2, there are, from Schedule 2 to Schedule 5, all of those compounds have an accepted medical use. And starting with Schedule 2, those compounds have a high potential for abuse or dependence. And then going down to Schedule 5, there's a decrease in the abuse potential or dependency potential. So essentially, it's a way to categorize substances, illegal substances.
And what schedule is cocaine?
It's a Schedule 2.
And how do you ensure that the weight measurement is accurate?
As I mentioned before, prior to using the balance to find a weight, we will perform quality control checks. And to do that, we will take 4 weights of a known quantity and put them on the scale and record what the scale reads out for those weights. And they have to be within a threshold. And if they are not, we will not use that balance. And we will not use that balance not only for that case or that day. We won't use it until an external company comes in and recalibrates it.
And then what did you do with this evidence when you were finished with your analysis?
I sealed it, as I stated before, I sealed it, put my initials over the seal, and then transferred it back into, the Willoughby Police Department's bin, for them to come pick it up.
One moment, Your Honor. Nothing further.
All right, cross-examination?
Thank you, Your Honor. Afternoon, Mr. Quebec.
Good afternoon.
So, in this case, you stated that when you put it through, there's two different acronyms. You said FRIR?
FTIR.
FTIR, okay. And, then the GCMS?
Yes.
Okay. And you said each of those, the molecules break apart in the same way and are measured. So does that tell you what percentage of a substance is one substance versus another substance?
No, it won't.
Okay. It'll just tell you whether something is present?
Correct.
Okay. And when you tested this white powder that you received in this case, do you test the entire substance or do you test a portion of the substance?
I take a small portion of the substance.
Okay. And then that portion of the substance, that presumably does not go back into the other substance once that's done, correct?
That's correct.
Once it's ran through the program, that part is gone.
Yes, we take a sample and put it into a vial, and that vial, the sample that's in there gets introduced into the instrumentation, and then that vial is discarded.
Okay.
So it does not go back into
Okay.
the evidence.
So what's left in that substance is not what was tested?
Correct.
Okay. And what the Lake County Crime Lab, they also do firearm testing, DNA testing, fingerprints, shoe prints. There's a whole wide range of different types of tests that you guys run
Correct.
on a regular basis. So in this case, there was no fingerprints or DNA swabs from the evidence that was given to you?
Correct. There was no request for that testing.
Okay. And normally is that the police department that makes that request?
Yes.
Okay, and that would be marked on the evidence when that comes to you, or how does that get to you?
If the agency or police department knows that they want those types of testing performed at the time of submission, they will put that onto the submission form. They will mark, yes, DNA or fingerprints or firearms or whatever they choose to. There are times where those requests come at a later time, so after the submission is completed. At those points, it may not be marked on the submission form, but we will notate whether or not that was requested.
Okay, is that normally requested in writing?
Yes.
Okay, but none of that happened in this case?
No.
Okay. And one moment, please. No further questions, thank you.
Thank you. Any redirect?
No, Your Honor.
All right, you may step down, thank you. State have another witness?
The state does not, and subject to a discussion of our exhibits, we would rest.
All right, ladies and gentlemen, the state has rested. That means they have presented all the evidence they intend to present. At this point in time, we have some business we need to take care of outside of your hearing, so I'll excuse you to the jury room. We should be with you in about 10 minutes or so. All right, have a seat. All right, exhibits 1 and 2 are already admitted. What is the intention with the remaining exhibits?
State's Exhibit 3 is cocaine, 4 is the lab report.
Okay, and with regard to 3,
We have no objection, Your Honor.
okay, 4 will not be admitted since it's a report that was testified to by Mr. Kubek. Ms. Carroll?
Thank you, Your Honor. At this time, we would like to move for Rule 29 motion, judgment of acquittal under Criminal Rule 29, even with all the facts construed in the light most favorable to the state. State's not met its burden of proof on each and every element of the offense charged. The evidence is insufficient to sustain a conviction, and a judgment of acquittal should be entered in this case.
Ms. Mulligan?
Your Honor, the state has produced evidence that the State's Exhibit 3 is cocaine, that it is 20, or more than 20 grams, less than 27 grams that came out of his pocket on the day that the charge was alleged. The victim, Kevin Corkin, testified that his life was threatened, that he believed his life was threatened, and that he would be caused serious physical harm by the defendant.
All right, based upon the testimony and the applicable standard, I'll overrule the motion for acquittal. Ms. Carroll, how do you intend to proceed?
Mr. Pate would like to testify, so we will be calling him as a witness.
All right, Mr. Pate, you understand that you have the right to testify in this case, correct?
Yes, sir.
You also understand you have the right to not testify if you do not want to.
Yes, sir.
If you decided you did not want to testify, nobody could comment on it. Do you understand that?
Yes, sir.
All right, it's your decision to testify in this case?
I would like to testify.
Okay. Then, are we ready to go right away?
Yes?
Okay, bring him in.
Once you're in the restroom.
Okay.
All rise for the jury.
All right, be seated. Ms. Carroll, defense ready to proceed?
Yes, Your Honor. At this point, we would like to call DeMarcus Pate to the stand.
All right, step forward, please. Raise your right hand, please. You swear testimony about gives the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat right here.
Good morning, Mr. Pate.
Good morning.
Good afternoon. Could you state your name and spell your last name for the record, please?
DeMarcus Pate, P-A-T-E.
And, can you tell the jury what happened on September 28th of 2023?
As far as which situation?
As far as when you came into contact with the Willoughby Police Department?
Should I start at the building management office? Or should I start when they came to my apartment?
When they came to your apartment?
Well, Officer Blackstone, Officer Slay, Detective Burrington and who else? Lieutenant Jordan was there too, but he was at the building management office. They knocked on the door and he asked me, who was it? Officer Blackstone. He asked me, well, originally I got sent back to my apartment because they asked me to leave the property, go back and pack my stuff. So probably like 5-10 minutes after that, they came back and knocked on my door. So they asked me like, yeah, we got a report of a threat from your neighbor or somebody. And I'm like, I don't know what y'all talking about. So they said, can you step out and talk to us? So before they even gave me a chance to answer, they pulled me out of my apartment.
Okay, and who pulled you out of your apartment?
Officer Blackstone grabbed my arm and pulled me out of my apartment. So I asked him, you know, what's going on? Am I under arrest? What's going on? He said, no, you're being detained for now. So I'm like, you know, being detained is basically like the same thing as being arrested. So he said, you know, that's not necessarily true. So I'm like, okay.
Were you in handcuffs at that time?
Yes, I was.
Okay, and were you taken to the cruiser at that time?
Well, when they put me in handcuffs, he got to go into my pockets. So I'm like, you know, if I'm not under arrest or anything, why are you searching me? Like, what's going on?
Okay, and then at that point, did they take you to the cruiser?
Yes.
Okay, at any point, did they ask you questions about what happened with the alleged threats?
All they basically said was they got reports from the guy Kevin saying that I threatened them.
Okay, but they didn't ask you your side of the story?
No.
Okay, and did you have an interaction with Kevin?
I mean, basically off of just what he said, we smoked weed one time. Actually, it was more than one time. I think we probably smoked weed like at least four or five times.
Okay.
But just that day, I think it might have been only like once or twice.
Okay. And when you were being driven back to the station, what was your impression of what you were being arrested for, or being charged for?
Well, what I was trying to state to the judge earlier when they pulled up the video, what's his name, Officer Rascal, during a trip to Willoughby Police Department, I asked him, you know, officer, what am I being charged with? He said, well, we don't know right now, but after I kept going on asking him about it, he said, well, as of right now, you being charged with trespassing. So I'm like, you know, how am I being charged with trespassing after y'all gave me permission to go back and get my stuff and leave?
Okay, and so how many times do you think he told you that you were just being charged with trespassing?
When I first got into his cruiser, because they put me in his cruiser when they walked me out of my apartment, my sister's apartment, and he acted like he didn't know what was going on. Then I got to breaking it down to him, like, you know, y'all violating my constitutional rights. I don't know what's going on here, you know. Y'all alleging that I did something, but y'all don't even have no actual proof of me doing anything, you know. So I'm like, you know, I'm just constantly asking him, like, what am I being charged with? I don't feel this is right. And he kept saying he don't know. As of right now, you're being charged with trespassing.
Okay, and did that conversation take place on the drive back to the Willoughby Police Department?
Yes.
Okay. I have no further questions, Your Honor.
Cross-examination?
Mr. Pate,
Yes, ma'am.
let's go back to when you were coming to the door of your sister's apartment, and you said Officer Blackstone grabbed you, put your hands in handcuffs, correct?
Yes, ma'am. He grabbed me and pulled me out of my apartment, my sister's apartment,
And then he patted you down,
put me in handcuffs, and then patted me down.
and he pulled something out of your pocket.
Yes.
He pulled a baggie with white powder out of your pocket.
Yes, he did.
And you said, that's powdered sugar.
Yes, I did.
And you keep powdered sugar in your pocket, right?
No, ma'am.
It's not powdered sugar, is it?
No, ma'am.
It's cocaine, isn't it?
Yes, ma'am.
You wouldn't have any reason to quarrel with the fact that it's more than 20 grams of cocaine, would you?
No, ma'am.
Okay. And that cocaine is a Schedule II substance, correct?
From my understanding, that's what the crime lab analyst said, so yeah.
You agree with that?
Yes, ma'am.
Okay. And it was in your pocket, under your control, when you were arrested?
Yes, ma'am.
Okay, no more questions.
Any redirect?
No, Your Honor.
All right, you may step down, thank you. Defense have any further witnesses?
We do not, Your Honor, we would rest.
All right. Let me see counsel up here real quick. Does the defense have another witness?
We do not, Your Honor, we rest.
All right, ladies and gentlemen, the defense has rested. Does the state have any rebuttal witnesses?
We do not, no.
All right, so ladies and gentlemen, you have received all the evidence you're going to receive. The next phase of this trial is going to be the closing arguments of counsel, and then I will instruct you on the appropriate jury instructions, and you'll hear some last-minute argument from counsel, and then you'll begin to deliberate. Before we do that, I'm going to give you about a 15-minute break here. Don't discuss the case among yourselves with anybody else. Don't try to find out any information from any other source, and do not come to any conclusion until you get the case. See you in a little bit.
All right, adjourned.
How are you splitting this?
First, second.
Okay. All right, see you in a little bit.
I think 15.
Cool.
You just want back.
Okay.
Who's over at juvenile, controlling the prosecution side? Oh, geez. It'll be a mess when it gets back.
What?
I'll see that at closing.
Well, I'm gonna go practice. I'll be back in a little bit. Is there anything you want to include?
No, just the fact that it was a illegal search and seizure. That's all I wanted to put on the record.
Well, like I told you before, that's not something that the trial is for. That was what this practice was for. Excuse me. Actually, are they all here, or do you think they're staying?
I don't know.
I'll cut from here.
Yeah, every year, yeah, they're out.
to see us, is that?
No, no, no.
Oh, okay.
No, she just wanted to be by where you were, she's gonna go, go over stuff.
Oh, okay. Oh, I thought they were calling
No,
us
no,
back
no.
in. Oh, my mistake. That's all right.
Nothing. At 24. I can go on more, but I hate the insurance messes it up. That's crazy. I got a wife and 2 kids, so it screws it all up. I wanna try and do 30, go in a drop.
God, did you know so fast, yeah. Well, I knew they were interviewing her today. I didn't know that.
They have it? Yeah, we.
Getting shown her office right now.
I didn't know that.
Sheppy.
Yeah, Peter. Well, that's good. I never knew. I don't know, since I started. Really?
Wow.
I don't think anybody uses it.
Hmm.
I don't know,
That's okay.
I haven't got it on,
Yeah.
see how it works yet, maybe it's not as good as the drop. I don't know.
I want it too hard.
Unless he says, just release it.
How's the boss doing over here?
Good.
Who's that again?
Brian Bowen. He does good, he doesn't mess with stuff. He's like Walter,
Who's on it?
Tracy, that's one we have, the Silver retired.
Who retired?
Silver. How many years you got Silver? Oh, how many years you got told?
Yeah, 2 years, 2 months, I carried over from the snow, but my first year was considered part-time.
Oh.
So, even though I could prove with my pay stub that I worked 54 hours a week on average, police department went down.
Oh.
I'm caught up in 29 years.
Yeah.
I'm doing first, she's doing second. She's the closer. Six and a half, 7. There's still stuff like in today's me.
I think for me, it's all the, that electronic shit, records are going through, like, trying to figure it out. Cause I'm old school, everybody else in the bureau is younger than me, like, we're going through all those fucking cell phone records.
Oh, it's horrible.
I like that, I'd rather get my teeth pulled.
Yeah, it's horrible.
That's where it's taken off.
Our computers aren't, like, you don't have a, you have to have a special computer to run a phone down, to even look at one. Oh, it's horrible. Thank you.
You're getting old, man. You do some yoga?
Yeah.
Some downward dog?
Yoga every day.
Guys call it stretching, it's not yoga. It just sounds better.
Never seen it like that.
That's true. Hey, whatever works. I kick my back up, I used to go, I stretch it, oh, it gets stiff. Yeah, no, that's why, I like lean forward. Oh, yeah, for you, yeah. Mine feel worse when I stand up, but, yeah, I get that. What's that? He's only been here about a year. He came from the jail, he was like 4 years in the jail.
That's good, I'm glad Frank's doing that.
And, we should,
Some that would not do
they
that.
can't find people, I mean, there's a couple on the road that came from the jail. They can't find people, that's what it work.
Is Double Dutch working today?
He is, you know what, I think he is, I don't know where the hell, oh, he's front door.
Here?
Yeah, he's at the front door, he works 9 to 5 front door. I had a EC's product agreements for this, it's through EC.
Who won it?
Because I think they brought belts, Diesel over and, tires.
What's wrong, man?
They gave him full top pay, top vacation, so, yeah, he was pissed.
Good for him.
So I don't know if he's, I don't think there's a ruling yet, I don't know if he's gonna win or lose.
I think he'll win that hands down.
He's gonna keep fighting to the end, till whenever he can't fight no more, so.
I don't know why they're fighting it, they should just give it to him.
Well, yeah, he did, they went to talk to the chief, you know, the chief said, no, I'm doing it. Then he went back to talk to the sheriff, and they said no, so. He had to do it, they didn't wanna help him, so. Yeah.
Will we have a recess like this, is it still live?
No. No, I know, I get it.
Don't blame him for doing that.
No, me neither.
Your mom, you wanna watch him?
No, but she has access to the camera, so if she's not at hearings, I think she's in good.
She's got 37 years.
Yeah, she's like one in the moment. She gets really likes her job. She likes her mom, actually. He's doing good. He loves it. He does his staff. He didn't fire anybody.
Good for him.
Not making waves.
He didn't want to be a people.
You know what the best job on the planet is?
Municipal court judge.
Yeah?
Probate is the best.
You think? I don't know.
They have no hearings on it, already controls the mess, he's not on one time. I was gonna be a judge and be a probate.
Probate? Yeah.
They got a lot of
But
power more than any
municipal is
other.
a lot more fun. I mean, you got
I
that,
don't know,
you know, you
municipal court, you're always running around.
Maybe.
Probate judge, you don't do anything. Sign some papers.
I'd be a bailiff.
No, you don't do that.
Didn't last a week.
Oh,
Here we
geez.
go, I love it.
There goes the goal, confidence killer. That was his goal to be a bailiff, now he's shut down.
That's right on par for Bob.
Oh, he gave me a impression.
Or, you know, four will not go back.
Okay.
So I already took that, and everything else is up here.
Thank you.
The,
Just
verdict
three
form.
then, yeah.
I didn't know we didn't take.
The juries won't be double-sided. I forgot to hit the thing.
I'm gonna use the cocaine. I mean,
The bigger
I
deal.
mean, excuse me, everyone that's not, no, I meant I'm going to, I don't know how to rephrase that, but you guys know what I mean.
She was, oh, yeah, I'm
You need to
using
call your boss, what?
Please, no one tell Chuck, please.
That's why she wanted to be a prosecutor. Oh, poor guy. I don't want to call her, because she's still trained. So I miss her just a little bit.
I told you, it is warm.
Everybody's got it on? So he turns it up for you?
Okay. We ready to go?
Yes, Your Honor.
All right, so All right, 7 pages, and then, did you say, Abby, you're first?
Mhm.
All right, let's go. All right, have a seat. Okay, you have on your chairs a copy of the jury instructions. You've each got your own copy, so you can either listen to me and look around or follow along on the paper, whatever you want to do. Okay, so I'm going to read the bulk of the instructions first. Then we'll have the closing arguments. The state will go first on the closing argument, followed by the defense. And then the state will have the last opportunity to address you since they have the burden of proof. Then I'll read the closing instructions, and then you will deliberate. All right, you have heard the evidence. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change a law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with the offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If after a full and impartial consideration of all the evidence you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty of that charge. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and you see that the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Some exhibits may appear to have been deleted, redacted, or omitted. There is nothing improper in any deletions, redactions, or omitted material, and no one has tampered improperly with such evidence without the knowledge of the state, the defense, and the court. In fact, such deletions, redactions, or omission have been done at the request and agreement of both parties. Any material that has been deleted, redacted, or omitted is irrelevant to your determination of the issues in this case. You are to infer nothing by what you think may be deleted, redacted, or omitted. Do not conjecture or speculate on what was not presented to you in the exhibits. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's testimony, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration the skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Police officers have testified in this case. You are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with possession of cocaine. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 28th day of September, 2023, and in Lake County, Ohio, the defendant knowingly obtained, used, or possessed cocaine, or a compound, mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Possess or possession means having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Possession of cocaine can be either actual or constructive. Actual possession exists when the circumstances indicate that the person had cocaine within his immediate physical control. Constructive possession exists when a person was aware of the presence of cocaine and was able to exercise dominion and control over it, even though the cocaine may not have been with his immediate physical control. Both dominion and control, and whether a person was aware of the presence of cocaine, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. Two or more persons may have possession if together they have the ability to control it exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. If you find the defendant guilty of possession of cocaine, it is your duty to deliberate further and to decide whether the amount of cocaine equals or exceeds 20 grams but is less than 27 grams. If you find the defendant not guilty of possession of cocaine, you will not consider the additional finding. In count 2, the defendant is charged with aggravated menacing. Before you can find the defendant guilty of aggravated menacing, you must find beyond a reasonable doubt that on or about the 28th day of September 2023, and in Lake County, Ohio, the defendant knowingly caused Kevin J. Corkin to believe that the defendant would cause serious physical harm to Kevin J. Corkin, his property, or a member of his immediate family. Knowingly has the same definition as in count 1. Cause is an act that in a natural and continuous sequence directly produces the serious physical harm to person or property, and without which it would not have occurred. Serious physical harm to persons means any of the following. A, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. B, any physical harm that carries a substantial risk of death. C, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. D, any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. E, any physical harm that involves acute pain of such duration so as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Serious physical harm to property means any physical harm to property that does either of the following. A, results in substantial loss to the value of the property or requires a substantial amount of time, effort, or money to repair or replace. B, temporarily prevents the use of enjoyment of the property or substantially interferes with its use or enjoyment for an extended period of time. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Immediate family means a person's spouse residing in the person's household, brothers and sisters of the whole, or the half-blood, and children, including adopted children. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all the offense charges. Charged. It is alleged that the offenses took place on or about September 28, 2023. It is not necessary that the state prove that an offense was committed on the exact day as charged in the indictment. It is sufficient to prove that the offense took place on a date reasonably near the date claimed. You will have in the jury room the following verdict forms. Each states, we the jury being duly impaneled and sworn, find the defendant. There is a blank. You will fill in either guilty or not guilty according to your findings. There's a place for 12 signatures. Your verdict must be unanimous, and all of you must sign the verdict form in ink on the line next to your juror number. And just a reminder, if depending on your finding on count 1, if you find the defendant guilty, there's an additional finding that needs to be made on count 1. If you find him not guilty, then you need not address that additional arguments. Remember, closing arguments of counsel are not evidence. They are designed to assist you. For the state, Ms. Bell?
Thank you, Your Honor.
On September 28, 2023, Kevin Corkin called 911 after being threatened by the defendant. You heard that 911 call in court here today. You heard about a theft where the victim named the defendant as suspect. heard the defendant decided to confront the person that made that report of the theft, Kevin Corkin. You heard the defendant told Kevin, people get killed for stuff like this. The victim asked, followed up, said, what do you mean? Does it mean you're gonna kill me? The defendant shrugged and nodded, confirming Kevin's suspicion. The police made contact with the defendant, and the defendant is subsequently arrested. He is patted down, searched pursuant to that arrest, and a baggie of cocaine is found in his front right pocket. At this point in the trial, you've heard all the facts and you've seen all the evidence. As the judge has instructed you already, as the prosecution, we bear the burden of proof. We had to prove each and every element of the charge you brought against the defendant beyond reasonable doubt. To find the defendant guilty of count 1, possession of cocaine, the state had to prove that on September 28, 2023, in Willoughby, Lake County, Ohio, this defendant did knowingly possess cocaine. There's no dispute as to the location, and there's no dispute as to the date. Well, let's talk about knowingly. How do we know the defendant knowingly possessed the cocaine? Well, sure, we can't look at the defendant's mind. In this case, he got lucky. On September 28th, when the cocaine was found, he told the officers, powdered sugar. He didn't say, oh, I don't know how that got there. These aren't my pants. I don't know what that is. Immediately said it's powdered sugar. He just didn't want the officers to know what it actually was. Today in court, he tells a different story, right? Immediately, yes, it's cocaine. He knew it was there, and he knew it was cocaine. Again, the elements are the defendant knowingly possessed cocaine. As far as possession, found directly in his pocket. The defendant admitted that here in court today. And we had to prove that it was cocaine. We had Mr. Kubek from the Lake County Crime Lab. He explained how he tested the cocaine, how he weighed it, and how it did in fact contain cocaine weighing 26.51 grams, which is more than 20, but less than 27 grams. And today in court, the defendant also agreed, yep, that was cocaine. To find the defendant guilty of count 2, aggravated menacing, the state had to prove it on the same date in the same place. The defendant knowingly caused Kevin Corkin to believe the defendant would cause serious physical harm to the victim's property or member of his immediate family. Again, this dispute started because Kevin reported theft and named the defendant as a potential suspect. You heard the defendant got wind that Kevin, the victim, snitched on him. So what does he decide to do? He decides to go confront Kevin. He bangs on his door, he wakes him up, and he says, what are you doing here? He tries to convince Kevin to rescind his report with the police. When Kevin says, no, I'm still pursuing this, that's when we get the statement. I'm in a gang, people get killed for stuff like this. We also heard that the defendant at one point raised his fist and went to ask if they're going to strike Kevin, but then he doesn't end up actually striking him. How do we know that the victim believed in this threat against his life? He called 911. Clearly, he was scared enough to call 911. He believed that the threat was credible. We ask that when you retire to the jury room and consider the evidence, you find that each and every element has been proven beyond a reasonable doubt. We ask that you remember beyond a reasonable doubt does not mean beyond all doubt, does not mean beyond a shadow of a doubt, it means reasonable doubt. The judge has instructed you on the law. I ask that you carefully apply the law to the facts that have been presented to you today during the course of this trial. And thank you for your attention.
Thank you, Ms. Carroll.
Thank you, Robin. Good afternoon, everyone. I do want to thank you again for your patience and attention during the trial. And when we began, when I stood here for opening, I asked you to pay attention to what evidence was presented and what evidence was not presented. Notice that there were 4 officers present in that interaction, and while 2 of those officers testified today, neither of those 2 officers were the ones that spoke to Mr. Corkin on the scene. Neither of those 2 officers were the officer that spoke to the people that Mr. Corkin said were witnesses on the scene. Detective Slay and Officer Rastel both said they didn't have any interaction with the witnesses, they didn't have any interaction with Mr. Corkin. They did none of the follow-up on that. No witnesses who could have witnessed this incident were called today, and there's a reason for that. Detective Burrington was not called to testify today. There's a reason for that. Patrolman Blackstone, who Mr. Corkin said was the one that came to talk to him after this incident happened, also wasn't called to testify today. There's a reason for that. When the state charges a person with a crime, they ask you to deprive a person of their freedom and liberty. That choice comes with a burden. The burden to prove beyond a reasonable doubt that these offenses occurred. So yes, Mr. Corkin did call 911 on that day. You heard that call. He was calm. He was a little irritated at the dispatcher for asking him follow-up questions. He was distracted, talking about the weather, said it's raining outside, so it's going to be a bad day. He said today that D, who he only knew as D, made threats to him, but he didn't know whether or not he meant them, but he didn't want to find out, and that's why he called 911. So he wasn't sure whether or not he was in danger. He wasn't sure whether he was going to have any problems, but he just didn't want to find out. Sitting here today, he even said he thought that Mr. Pate was the person that he knew as D, but he couldn't really be sure. He didn't know him very well, and it's been a while since he's seen him. He didn't know for sure if that was him. These are essential elements in the offense of aggravated menacing. He has to prove that he knowingly caused him reason to believe that he would get seriously physically harmed by Mr. Pate. So the fact that it's Mr. Pate is a dispute, and the fact that he actually thought that he was going to be harmed by him is a dispute, based on Mr. Corkin's testimony today. When officers talked to him originally about the money, he had alleged that Mr. Pate was the one that stole the money. Then when they were talking to him later, he alleged that it was his neighbor Valencia maybe that took the money. He wasn't really sure. So there's been some inconsistencies with his statements all along the way. Mr. Corkin stated that officers didn't even talk to him before they went and arrested Mr. Pate. Then they came back and talked to him and got information about what the allegations actually were. And it was after they went over there to talk to him that they found this white powder in his pocket. And with respect to the cocaine, Mr. Kubek from the crime lab did state that the part of the powder that was tested was a small portion of the large bag of powder, and only that small portion was tested, and they're not able to test how much of that powder was cocaine versus other substances. They could just tell that cocaine was present. So we would ask you to find Mr. Pate not guilty on both these charges.
Thank you. Ms. Mulligan?
Thank you.
It's cocaine. It's more than 20 grams. You heard scientists tell you that. You heard DeMarcus Pate tell you that. It came from his pocket. You heard the officer say, that's where he saw it come from. And you heard DeMarcus Pate say, that's where it was. The evidence is uncontroverted. Uncontroverted as to each element of possession of cocaine. There's no issue as, did it happen on the 28th? Well, nobody said it was anything else. Is it cocaine? Nobody said it was anything else. Is it more than 20 grams? Nobody said it was anything else. Did he have it in his pocket? Everybody says he did. Did he threaten Kevin Corkin? That's what brought him over there. Did Kevin Corkin think that he was in danger of serious physical harm? Yeah, that's why he called 911. Is he an odd fellow? Absolutely.
For what time?
You heard the 911 call. He asks the dispatcher, what should I do? Should I move? That's somebody who's not scared the way you might, the way I might, the way somebody else might. But he called to report a theft, and the guy that he named found out about it. Called the police responded immediately. And they found the cocaine. Convicted.
All right, thank you. If you want to look back at, I'll pick up again on the bottom of page 7, the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you based solely on the facts presented to you in this courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so the state and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you have reached a verdict. If you took notes during the trial, you may take your notes to the jury room. The fact that the notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of the jurors who do not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the jury instructions, and verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should only do so after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. In order to return a verdict, it is necessary that all jurors agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on the law as the court has given it to you in these instructions. Nothing that the court has said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have any question or request during your deliberations, your foreperson should write that question or request on a paper and notify the bailiff so the question or request can be delivered to me. The court cautions you, however, with regard to any message or questions you might send that you should not reveal your numerical division at the time or the status of your deliberations. It should be reduced to writing so there will be no misunderstanding as to what you request. It should then be delivered to the bailiff who will submit it to the court. When all 12 jurors agree upon the verdict, you will sign the verdict form and advise the bailiff by using the buzzer in the jury room. You will then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberation to request transcripts of various witnesses. There are no transcripts. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not to discuss such matters. It is the lawyer's duty to protect your desire not to talk about the case if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence on you for the purpose of getting you to talk about the case. Once 12 members of the jury have agreed to a verdict on each of the counts and have signed the corresponding verdict forms, the foreperson will notify the bailiff and you will be returned to the courtroom. You may now start your deliberations.
All right, jury.
All right, anything else to put on the record from the state?
No, Your Honor.
Defense?
Hey, Your Honor.
Okay.
So, if he didn't have you take him downstairs, or
Yeah, once all these, they're taking breaks, whatever, once I'll get back, we're gonna take a break downstairs. She's, with more. That's,
do you need anything to eat?
all right, fun's over, back to work.
Did you print out the questionnaire for those? I'll give those back to Bob. Oh, see how they're supposed to do, do you have a copy? I don't, I didn't print it up.
Yeah, I was thinking, but they're way.
Go where?
Go over to the victim's office, like, kind of nice.
Oh, Carolyn, not your mouse again. Carolyn.
Oh, thank you.
Oh, no, I was just seeing whether it was, if we were gonna go back and you were just gonna call us.
Yeah, what I'm saying, you have these are your questions. Yeah, I'll text you and,
Okay.
Carolyn.
That would've been a total face plant. Alright.
You need another couple of weeks to take over tomorrow.
Uh-huh, yeah. Well, after I sprain my ankle at Willoughby Muni Court, I don't need to be, doing any more damage. Oh, yeah. Alright, let's get it going.
Do you want to grab his? Well, we'll just leave that, or maybe come back. Maybe take a.
seated, please. All right, has the jury reached a verdict?
Yes, we have.
Would you hand that to Mr. Gonzalez, please? All right, in the case capture, State of Ohio versus DeMarcus T. Pate, count one, possession of cocaine. We, the jury, being duly impaneled and sworn, find defendant DeMarcus T. Pate guilty of possession of cocaine as charged in the indictment. Dated February 5, 2024, signed by all 12 jurors. Additional finding that count one, we, the jury, find that the state did prove beyond a reasonable doubt that the amount of cocaine equals or exceeds 20 grams but is less than 27 grams. Dated February 5, 2024, signed by all 12 jurors. Count two, aggravated menacing. We, the jury, being duly impaneled and sworn, find a defendant, DeMarcus T. Pate, not guilty of aggravated menacing as charged in the indictment. Dated February 5, 2024, signed by all 12 jurors. Does either side wish to have the jury polled?
Yes, Your Honor.
All right, I will ask you by juror number if this is this your verdict, and answer yes or no. Juror number one, is this your verdict?
Yes.
Juror number two, is this your verdict?
Yes.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes.
Juror number six, is this your verdict?
Yes.
Juror number seven, is this your verdict?
Yes.
Juror number eight, is this your verdict?
Yes.
Juror number nine, is this your verdict?
Yes.
Juror number 10, is this your verdict?
Yes.
Juror number 11, is this your verdict?
Yes.
And juror number 12, is this your verdict? Juror number 13, is this your verdict?
Yes.
All right, thank you very much, ladies and gentlemen. If you can go back to the jury room, I'll be back in a few minutes to talk with you. Be seated. All right, I'm going to refer this for a updated pre-sentence report. Sentencing will be February 21 at 9:30 a.m. and the bond is revoked. Is there anything else, Ms. Mulligan?
No, Your Honor, thank you.
We would like
And a
to,
victim impact statement also. Yes, go ahead, Ms. Carroll.
victim impact statement?
Oh, never mind, that was not guilty, forget it.
We would like to ask for a drug and alcohol evaluation.
All right, drug and alcohol evaluation also. All right, we're adjourned.
Someone in the front. You can vote.
Just absolutely. 9:30, I think you said, yeah.
That's right, I'll finish.
Good game. GG.
What else can you do?
Hey, Carolyn, can you send over to someone to substitute and take a picture and come and get some stairs? Unless you wanna wait after the break, I don't really care, whatever you wanna do. I mean, whatever you're supposed to do.
Yeah, I'll find out what I'm supposed to do, and I'll do it.
I mean, yeah, or just, you can keep it.
He's still gonna try. I'm sure he will.
Send it back, yeah, whatever they give us.
I don't know what to do.
I'm trying to get rid of all my crap from years ago, so. Not real good about getting rid of shit.
All right.
Mission accomplished.
Thank you, good job. I'm gonna go get my 10 mark on my hair.
You'll do your first, yeah. Oh, no, I didn't bring it.
You're gonna substitute it, Bob, and send somebody else.
Okay.
Good on the new.
Oh.